Honorable members, good morning, Honorable Minister and members of the press. Honorable members, I welcome you to today's sittings, that is Wednesday, the 16th of September, 2020. And I recognize the presence of the Honorable Attorney General. And I also thank the Honorable Attorney General for successfully carrying out the first stage of the bill, which is the Constitution of the Republic of the Gambia 2020 Promulgation Bill 2020. Honorable members, we shall commence today's business with the second stage of the Constitution of the Republic of the Gambia 2020 Promulgation Bill 2020 in accordance with Clause 66(2) of the Standing Orders of the National Assembly, which reads, at the conclusion of the proceedings on the first reading or on any subsequent stage of a bill, the next stage may be taken either forthwith or upon a day to be named, provided that the second reading shall not be taken no sooner than 1 working day after the first reading. Clause 67(1) of the Standing Orders also reads, on a motion being moved that a bill be read a second time, the general merits and principles of the bill may be debated. During the process, honorable members, the Assembly will be guided on procedural matters by provisions of the Supreme Law of the land, which is the 1997 Constitution, specifically sections 226 subsection 1 and subsection 2 subsection B. Section 2261 reads, subject to the provisions of this section, an act of the National Assembly may alter this Constitution. Subsection 2B also reads, the bill is supported on the second and third readings by the votes of not less than 3/4 of all the National Assembly members. Honorable members, I urge all of us to observe the necessary provisions of the 1997 Constitution and the Standing Orders for guidance. Honorable members will recall that on Monday, when we resumed sitting, the Honorable Member for Serekunda raised certain concerns, and I am happy to report that the issue has been solved. Thank you very much. Clerk, can we proceed, please? Thank you.
Correction and approval of records of votes and proceedings of the National Assembly sitting of Monday, 14th September 2020.
Very much. Honorable members, the record of votes and proceedings of the of the National Assembly sitting of Monday, the 14th September 2020 is before us for correction and approval. Can any honorable member please move that the said record of votes and proceedings be considered and approved? Yes, honorable member for Jimara.
Thank you very much, Honorable Speaker. I rise to move that the record of vote and proceeding of the National Assembly sitting of Monday, 14 September 2020 be approved and corrected.
Thank you. Any seconder? Yes, Tumana.
I rise to second.
Thank you. It has been moved and seconded that the record of votes and proceedings of the National Assembly sitting of Monday, the 14th of September, 2020 be approved. Any issues or observations from honorable members? I believe the records had earlier on been circulated and everybody has a copy. I'll start with Fonyi Bintang.
Sorry, on page 1, here I have the heading, Mariam Jagentin. Under it, you have Monday, 11 September. I think Monday was 14 September. On top there.
Thank you. It's noted. Thank you very much. Any more on page 1? Any corrections on page 1? No. Thank you. Page 2. Can we please confirm the attendance, whether the records are correct? Kiang Central.
Yeah, Honorable Speaker, my name is not been captured and I was here.
Check, please, can we draw his attention? Look at page 4.
Is
Sorry,
there?
page
Yeah,
2,
yeah.
number 4.
Yeah, I run through it quickly. For myself.
Honorable Kian Central. You're okay, good. Jimara, please, thank you.
Yes, I think Honorable Jokadu was here on Monday, but then I could not see his name under the present list. Jokadu, Saliu Jao. Yeah, but he was present.
Opanyomi? No? Okay. Tumana?
Okay, I don't know whether we are at page 3. 2, okay.
Fonyi Prefect, are you okay? Good, thank you. Okay, we move on to page 3 then. Yes, Tumana, page 3.
Yes, in attendance, page number 29, where you have Honorable Demba Sow, Nyamina West. I think that's a mistake.
Actually, this continues to be an issue, and I have drawn the attention of the table office, but we'll try to solve it once and for all. Thank you. Thank you. Any more on page 3?
Yes.
Page 3, yes, Sabah Sanjal.
Yes, number 36, Honorable Fode Gassama, nominated member. I think he's no more a member, honorable member. And if you go down further, you have number 48, Honorable Keva K. Barrow, Majority Leader. The title is under the names. Likewise, the Minority Leader. I think it should be corrected.
Well, I don't see anything wrong with the name, except that probably the alignment on the line is not very tidy.
What I mean is, you have Keva K. Barrow, Majority, the Leader, and Combo South is under the name column. It should be under the title column. For consistency, that was what we are having. Yeah. Yes.
Yes, thank you, Sani Mentere. Are you on page 3?
Yes, my name is not captured.
Previous page. Okay, thank you. Yes, we will ensure that it is inserted. Yes, Fonyi Jarol.
Thank you, Madam. On that day, I was absent and I've seen my name on the number 21.
Thank you. Any more? Yes, Honorable Deputy Speaker.
Not captured. My name is not captured. Yes, I was here.
Table office, please take note. Any more omissions or wrong spelling? Yes.
Honorable,
Nominated member.
thank you. Honorable Speaker, they still have Honorable Fode Gassama in my place on the list. It's corrected. Okay, thank you.
Also the number, where? 36. Yes, thank you. Okay, thank you very much. Any more corrections, honorable members? No? Then page 4. Page 4. Yes, Woolley West.
But the last paragraph on page 4 appears to be written very clumsily. The last paragraph on page 4 needs to be rewritten because it is, well, the whole paragraph is written in a very clumsy way. For example, you say, Honorable Speaker, pray to Allah the Almighty to continue to guide the Assembly throughout this third session, ordinary session of 2020 in very
Point of order. Point of order. Point of order. Yeah.
Point of order. I think this is a serious, it needs to be corrected. Yeah, the language is not proper. So he's drawing our attention to it so that it can be amended.
Yeah, but we are deviating from our laws, Honorable Speaker. We are deviating from our laws.
I haven't given the floor yet. I just want to ensure that let the table office capture it and make sure that it is corrected, because it doesn't make sense for it to read, the Honorable Speaker prayed to Allah the Almighty to continue to guide the Assembly throughout this third ordinary session in very uncertain times admits. I mean, obviously it doesn't make any sense. So that's why he is saying that it should be rephrased and put in proper language, which I think is right. So table office, please take note of that whole paragraph. Page 4, it needs to be rewritten. Now, I will take Jara East. One by one, we will get there.
Honorable Speaker, thank you. I'm rising on clause 26(2) of the standing orders for members to rise while addressing the Speaker. Thank you.
Salum.
Well, it's the same thing also. He should be standing up when he's addressing the Speaker. He should be standing up. The Honorable Member for Woodley West should be standing when he's addressing the Speaker, so he should not sit down.
Honorable Woodley West, probably they want you to set better examples, being the veteran or one of the veterans, that you rise when addressing the chair. Thank you. Yes. Any more corrections on page 4? Any more? No? Okay. Page 5. Teachers. We are satisfied with yes, Woolly East.
Yes, when you, Honorable Speaker, when you go to question put and agreed to, the last paragraph, the ayes have it should be part of the preceding paragraph. Did you see it? Those in favor, please say aye. Those not in favor, please say no. The ayes have it should be part of that one. Should be separated from the. All right.
Yes. Page 7. Yes, Yes, let me take Kian East. Page 7.
Oh, sorry. The motion was ruled out by Honorable Speaker, arguing that she will not make an immediate decision but promise to address the situation with due diligence. So rule out, a word is missing. I think it should be by the Honorable Speaker. We insert by, or maybe we put a full stop and said the motion was ruled out, and then pick a new sentence and said Honorable Speaker argued that she will not allow those two. Thank you.
Yes, the same paragraph. Honorable Speaker argued that she would not make, instead of she will not. And then when you go to under the Attorney General, the second line contained in the order paper would be done today, instead of will be done today. Thank you.
Honorable Member for Basse.
Honorable, thank you. If you look at the last paragraph, at this juncture, Honorable Speaker acknowledged that the bill has been read a first time and appointed. I think we agreed on Wednesday. That's today. But we have Tuesday.
In time, the honorable member for Lower Badibu drew our attention, and the issue of the time, the computation was discussed, and then we agreed for Wednesday. So I think you're right. We can indicate here that we agreed on Wednesday. And that was the reason why the assembly was adjourned to Wednesday today instead of yesterday. Thank you very much. Page 8. Yes, Woolley East.
Yes, page 8, last paragraph. We said section by section, but I thought we did it by part by part, rather than section by section.
We did it part by part.
Yeah, okay.
Thank you. The committee, can you read the amendment at the consideration stage so that it reflects what happened or what was done at the consideration stage? Thank you. Yes, Jan.
Yeah, thank you. On the consideration stage, the Honorable Speaker reminded the Assembly that the joint committee should be committees, joint committees. Thank you. Page 8, on the consideration stage, the Honorable Speaker reminded the Assembly that the joint committee should be committees as opposed to committee. Thank you.
No. It's one joint committee. No, it's a committee. It's one joint committee.
There are two committees, but if the committees are joined, it becomes one committee. If they are joined, it becomes one committee. So I think it's correct that we say the joint committee. Are we satisfied with page 9, first, second, third, fourth, and fifth paragraphs?
No.
Or you're still, yes, Woolley East.
Thank you. Honorable Speaker, the number 2, it says part force. Did you see that? We took out the S. Was incited instead of on the bill, we say in the bill. And then when you go to 3, section 26, subsection, we should add section there, subsection. And then when you go to 4, again, at the end of the line, you have section 30, subsection. You put section there again. And then on the 5th one, the word female was added between 1 and representative at section 30, subsection. And then the last paragraph, where you say reprint, provide a reprint capturing all amendments. Yeah, thank you.
I'm sure the legal draftsperson, whoever he or she is, will take note of that, because I don't think they usually use even sub. It will be read section 30 in brackets G, and it's automatically read as subclause or subsection. But I'm sure the experts will do when they bring the final version. Thank you. Page 10. Sorry. Are we satisfied with the amendments at the consideration stage? Yes. Honorable Member for Serekunda.
Yeah, Honorable Speaker, we started by considering the amendments on the 72 paragraph 4. I think it should be mentioned because the issue was about notice and we saw that without notice. So there was this submission by the member for Serekunda that the amendments are submitted for consideration as we move clause by clause. On the 9, we are talking about section 26. It's better we put clause 26 because this is yet to be an act. So we were reviewing it clause by clause. Since it is not a detailed one, Honorable, we will look at it and we'll just say with amendments. We'll adopt it, Honorable Speaker, with amendments.
Probably, if we want the details, what I can suggest is for the clerk to get in touch with the co-chairs and then sort it out and finalize it in a neat way.
Thank you. We'll do that.
Thank you. Seconded that the record of votes and proceedings of the National Assembly sittings of Monday, the 14th of September 2020 be approved with amendments. Those in favor, please say aye. Those not in favor, please say no. So the ayes have it. But before we proceed with clerk, please may I just recognize the presence of officials from the CRC. They are here with us today. Thank you very much. Clerk, can we proceed?
Yes, ma'am. Bill, Standing Order 67-1. Second reading of the bill. Debate on the general merits and principle of the bill. The Constitution of the Republic of the Gambia 2020, Promulgation Bill 2020, by the Honorable Attorney General and Minister for Justice.
Thank you very much. Honorable members will recall that the first reading of the bill, that is the Constitution of the Republic of the Gambia Promulgation Bill 2020, was done on Monday, 14th September 2020. And the second reading scheduled for today will be done accordingly in accordance with Standing Order 67, subclause 1. But before inviting the Honorable Attorney General to move a motion for the second reading, I wish to emphasize again that the bill shall follow due process and procedures as laid down in the 1997 Constitution, specifically Section 226, which is very critical. The said section, that is section 226 of the 1997 Constitution, is equally important given the fact that the bill seeks to repeal the existing Constitution, which is still in force. Furthermore, as a legislature, we are required to follow the due procedure as provided for in the standing orders as far as government bills are concerned, and that is our standing orders clause 67 to 79. But however, we must take note that as a matter of trite law, the 1997 constitutional provisions will always take precedence. And for the purpose of clarity and as presiding officer, I wish to state that as a matter of first instance, the bill has satisfied the requirements of section 2262A, which states, and I quote, subject to subsection 4, a bill for an act of the National Assembly under this section shall not be passed by the National Assembly or presented to the President for assent unless A, before the first reading of the bill in the National Assembly, the bill is published in at least 2 issues of the Gazette, the latest publication being not less than 3 months after the first, and the bill is introduced into the National Assembly not earlier than 10 days after the last publication. Accordingly, honorable members are already aware that the bill has been published twice in the Gazette, the first being on the 28th of May, 2020, and the latest publication, which was on the 28th of August, 2020, not less than 3 months from the first publication. The respective Gazette publications have been circulated to all honorable members. Therefore, pursuant to, clause 67(1) of the standing orders, I now invite the Honorable Attorney General and Minister for Justice, to move a motion for the second reading of the bill entitled The Constitution of the Republic of the Gambia 2020, Promulgation Bill 2020. Now, Honorable Minister.
Clarification. Point of clarification.
Sorry.
Honorable Speaker, you've read clearly section 226, 2B, which says that the bill is supported on the second and third reading by the votes of not less than 3/4 of all the members of the National Assembly. Do we have that quorum? I think we should first check into that before just moving with the debate, because ultimately we'll have to vote after the second reading.
To confirm that we have the required number of members.
Yes, Honorable Speaker, because we'll be voting.
We are aware of the constitutional requirement, but I just want to confirm what you have just said. You want us to confirm that at least we have 42 members.
Yes, Honorable Speaker, I'm proposing that we confirm.
That we have at least 42 members, right? Yes. My technical team is thinking that we're taking a vote. We're not taking a vote. I think we're just being on the better side of caution, just to ensure that we have the requisite number. That's all, but we're not taking a vote. I think, are we together? Yes, just to confirm. It may be easier for the table office if you raise your tags for him just to count. Thank you. You start from the last, yes. It's just to confirm. Honorable members, it's been confirmed that we have 51 members. So are we all together? We're satisfied? Good. So we can now proceed. Thank you. Thank you very much for that observation. Now, may I invite the Honorable Attorney General? Thank you. Honorable AG.
Thank you very much, Madam Speaker. Honorable Speaker, I wish to move that the bill entitled The Constitution of the Republic of the Gambia 2020, Promulgation Bill 2020, be read the second time. Briefly, Madam Speaker, the objects and reasons of this bill is to seek to provide for the promulgation of the Constitution of the Republic of the Gambia 2020 and to repeal the Constitution of the Republic of the Gambia 1997. I move on those terms. Thank you.
Very much. Any seconder? It is Fonyi Bintang Karanlai.
Thank you, Madam Speaker. I write to second the motion.
Thank you very much. Motion has been moved and seconded, and in accordance with clause 67(1) of the standing orders, I will now open the floor for debate on the general merits and principles of the bill. Before giving any honorable member the floor, I wish once more to strongly emphasize Standing Order Clause 67(1), that the debate shall strictly be on the merits and principles of the bill. And I will not hesitate to call any honorable member to order if there is any deviation from this. The debate is now just on the merits and principles, not on the details of the bill. Furthermore, after the debate on the general merits and principles, a vote shall be taken on the second reading as required by Section 2262B and 4B of the 1997 Constitution. A vote of not less than 3/4 of all members is required before the bill can proceed to the next stage of the process. This procedure is quite peculiar, and I wish every honorable member to kindly take note of it. Now, I will now invite honorable members who wish to partake in the debate to do so. And can we take down the honorable members? You can take from this side and also from this side. Thank you. Office can record it properly. From this side, I have to go. Just to confirm the list that has been given to me, from my right-hand side, I have Kumbus, Kiang Central, Birkama North, Birkama South, Bundunka Kunda, Jara East. Any more on this side? Central Badibu, yes. Can I? From here, I have nominated member, Yasin Seka, Wuli West, Serekunda, Wuli East, Banjul Central, Basse, Nyamina East, Minority Leader, Nyanija. Jara Central. Yeah, Banjul North, you are here. Am I right? He's sorry. Oh, it's Banjul Central, yes. Banjul North and Jara Central. Please, we want to take the list so that we'll be able to manage the time. Lower Nyomi, Tumana.
Fine. Honorable Speaker.
Lower Salum. Lower Salum has raised his tag, yes. Any more? Yes, sorry.
Honorable Speaker, is it that we want to make it a condition that people should be registered all at one time before the proceedings start? Is it that's what we want? Is that provided in the
No, we
standing
are
order?
not. We are not. Okay, sorry. You've asked a question.
As the proceeding is going on, it's not finished, can raise his hand for if you feel any time to make his intervention.
We have, you will agree with me that there has been instances when people have indicated that they want to have the floor, and when it is time for them, they withdraw. So it's just for us to manage the time, not that we are conditioning anybody. Nobody is being conditioned, anything. It's just for purposes of time management. And also to be fair, because I don't want any on my right hand to say that I am giving them preference over my left side or in front of me. That's the only reason, so that I'll be taking from here, from there, from there. Are we all together? Thank you. Honorable Member for Kiang Central, thank you.
Thank you very much, Honorable Speaker, for giving me the floor. Honorable Speaker, first I want to thank the members of the Constitutional Review Commission for a job well done. If you looked at the draft that we have before us, it has really captured the aspirations and wishes of the Gambian people. They have done an extensive consultation. I want to believe for the first time in the history of the Gambia that people were asked as how they should be governed. Consultation was done in a more detailed manner. Honorable Speaker, the essence of review is to improve on the current constitution that we have. And then I want to believe it's one of the reasons why we are seeing the emergence of new independent institutions in our draft. You have the Anti-Corruption Commission, the National Human Rights Commission. We cannot strengthen our democracy in the absence of such institutions. So I believe the draft constitution, if you go through it, you will find out that an expansion has been done in that area. Honorable Speaker, the Teacher Service Commission and the Health Service Commission are all new elements that have come across in the draft. And these are all institutions that are really essential. These are all institutions that are really important to care for the people that are affected in those sectors. So I believe the draft constitution, the National Assembly members will have the opportunity to go through and then look at it in detail. Honorable Speaker, the public finance also is another area that has been exhausted. Transparency and accountability is very essential to ensure democracy, and we need to have protective mechanisms in place. They are really key. So I want to believe the CRC has really done a better job. Honorable Speaker, we are all aware of the current development that are really happening within the sub-region. It is important that we have what is called a presidential term limit. These are all measures to control, these are all measures to protect the people, to put an end to dictatorship, and as well as stop corruption. Because what I realize is the belief is that when you stay more in power, the probability of you being corrupt is there, and it is very huge. So this is why I think we are one of the few countries, if not the last country in the entire sub-region, where in our current constitution, we don't have a presidential term limit. And then we must not stop at having only presidential term limit, but we must entrench this particular provision in the Constitution to an extent that nobody will be able to amend it to go for a third term or whatever. We all know what is happening around Africa. And then if this is not done, our democracy will not be enhanced. Honorable Speaker, the National Assembly in the draft constitution is being looked at, and then the autonomy of the National Assembly is one of the things that is really extensively looked at. And I want to believe that the National Assembly, being an oversight institution, should be independent in terms of their functions, in terms of their finances. So these are some of the areas that was looked at, and I'm really satisfied the way and manner in which that particular person has been, dealt with. So these are some of the few observations I've made on the draft constitution under the Speaker, and I really thank you for giving me the floor. Thank you very much.
Thank you. Honorable Member for Sami.
Thank you very much, Madam Speaker, for giving me the floor. Madam Speaker, I would also want to thank the CRC for a job well done. For the simple fact that this CRC, they have gone round to all the areas, hear from them what they want to see in the draft constitution. What we see in the draft constitution, it is not the making of the CRC. It is the making of our own people. It is our own people that they want to see a change the way this country is run. So, Madam Speaker, I definitely want to thank the whole Gambians, those in the Gambia and those in abroad, because they all contributed in drafting this draft constitution. And the CRC, they do all best to see that their inputs are there. So, Madam Speaker, when we look at the chapters, the old one and the new one and the parts, we can definitely see that there is a lot of improvements. There are a lot of improvements there. Like if you look at the specific rights, you go to look at the old one, the rights that are identified for the new draft constitution are not in the old ones. So, Madam Speaker, this draft constitution is a very good one. When we look at the governance issue in the draft constitution, it's welcoming. If you look at the old one, most of the appointments are done by the president with no confirmation. But when you look at the current one, the draft one, it has to be confirmed by the National Assembly. So I think this is a very good draft, Madam Speaker. And the autonomy of the local government, for them to do their work effectively, independently, without any hindrance. It is clearly stated in the draft constitution. And even the autonomy of the National Assembly, as the others have said. For us to do our work effectively, we must have our independence, so that we can move freely. Whatever we want to do, which is in line with the Constitution, we can do it. So, Madam Speaker, when you look at it, democracy, in the new one, you look at it, you will definitely know that this new draft has indicated gender representation. But the old one does not indicate. But this new one went up to an extent of identifying every region, the representation of women, and even persons with disability. And there will be no nomination for the president. So I think even youth representation is also indicated. As the other speaker said, the term limit is also there. We all know where we are from. Where we are from. We don't want somebody to overstay there for 20 years. Those days are gone, Madam Speaker. Those days are gone. So on that note, I thank the CRC and I thank the whole Gambians for coming up with this draft constitution. And I'm definitely in support of it. Madam Speaker, I thank you very much.
Thank you very much. Honorable nominated member, Ndeyasin.
Thank you very much, Ma. I want to commend CRC. Really, they need a tap at the back. And then, Honorable Attorney General, I thank you for moving this to be supported. The principles and merits. It is a history that this constitution will replace the 1997 constitution amended for 52 times or more. And this is what we are really trying to do away from. Gone are those days when the Gambians do not even know anything about the constitution. There was a time when I listened to the debate of the National Assembly. By then I was not working. I even did not know that I may be a National Assembly member. When I had one of the members of this National Assembly, not this one, but now some of that time is a history and I will never forget. When somebody talked about the Constitution, one person got up and said, this is not a library of a Constitution, where you know that you are talking from the National Assembly. By then, I even didn't know, but I just got up. I was sitting, but I have to stand up. I say, if the National Assembly is not the place for us to discuss anything about the Constitution, then where are we going to talk about the Constitution? By then, nobody, even the Gambians, were not interested to know anything about the Constitution. And this Constitution is the Constitution that is guiding us. It's our guidance. That is why, where were we we were at nowhere. And those days have gone, and it should go now. It should be a history. And here, we, the National Assembly members, the Attorney General, the CRC, everybody should try and leave a good legacy, even the President. That this National Assembly is the National Assembly that come up with Gambia to change, or Gambia has decided, or you give it any other name. We are saying that when we come here, we will reform as much as possible. And this, I think this is the right way to reform. That is to come up with this, to change the Constitution. Even to change the Constitution shouldn't have been so long. We should have just go with the 1997 Constitution and look at those strike union laws and take them out. But nonetheless, better late than never. This is a way forward, and we appreciate it. Now, Honorable National Assembly members, let us support this Constitution. How many millions have we put in this Constitution just to make it pass? I think we should try by all means to make sure that the Constitution from the CRC is here before us. Nothing can stop us from making some changes. Even me, I have some issues. That is the disability. When it comes to visually impaired, I heard on the radio that everything is on Braille, it's on audio, but I haven't seen it yet. I was so happy that if I go to my pigeonhole, I'll find it in Braille. But it's not. I cannot read it on my own. I have to use my children to read for me, or to go to friends to read for me. Even if I have it on audio, it will be better. But if you see me talking all these things, it's because I have to find ways and means to know what is in the Constitution. So the representation of the disability, there is a room for improvement. There is a room for improvement. We need the Braille version, if not the audio version, for visually impaired. We need the large print, if not the audios for those albinos, because you see, the printing will be somehow small. They will not be able to read it properly. So when it comes to other, that is why I'm saying disability is a package. Maybe when it comes to other type of disabilities, maybe those with wheelchairs and those with hearing impairment, maybe you can do it with them. But what about the other type of disabilities? That is why there was a time when I say people living with disabilities, many people are saying physically challenged. Physically challenged is only one aspect of disability. I think it's better when the need arises, we Google and know what is disability and what is the type of disability that is in this world. There are many, many types of disabilities. Don't just rely on physically challenged. Physically challenged is just one aspect of disability. Maybe those people, what they will need is the structures, the buildings. Those are the ones that are using wheelchairs and crutches. But when it comes to other types of disabilities, they need more than that. How did I go to school? Was it that these printed versions are given to me so that I will be able to read? I can read, I can write, but here I cannot, because I don't have any writing material here before me for visual impairment. And I cannot read. Even this, I have to depend on my people. I cannot read the records of words and proceedings. It is just brought here on my table, so I have to struggle to let people read for me, or I listen attentively. So these are issues that we really have to put on board. I really thank you. I thank everybody. And long live the Gambia. And we pray for the peace of this country. Thank you.
Honorable, may I call on the honorable member for Basse? Thank you.
Madam Speaker, thank you. Also join the colleagues who have spoken before me to recognize the effort of CRRC and the cooperation of every Gambian within and outside the country, and all political parties and all community members. They have done their work according to the according to the Act of Parliament, which mandated them to provide a constitution for the people of the Gambia. And they cannot do so without getting the view of the Gambian people. The view we are given to them, and they came up with a draft which is before us today in a form of bill for promulgation. Honorable Speaker, my points here are going to be very limited, as I also reacted during consultation. But my reactions are not being catered in this constitution. Honorable Speaker, I want to believe that if you want to protect your languages, the protection begins in the Constitution. The language policy of any country is read in the Constitution. This Constitution also didn't come with a language policy if you compare to other countries' constitution. For example, in Senegalese constitution, you have the official language of Senegal, but Mandinka, Wolof, Sere, Pular, etc. are the national language. They are given constitutional recognition. And that constitutional recognition of the national languages will help the Ministry of Education to come up with a better language policy. But still, we don't have that in the Constitution. That means there's no language policy in this country. And that has been my argument here at the floor of the House. And when I was consulted, this was my position. I hope that it will be captured. But unfortunately, for one reason or the other, it is not captured. So therefore, from my own point of view, a constitution without a language policy will give us a very difficult starting. Because all that we are trying to promote, being a culture, being a religion, being education, whatsoever, politics, cannot go without language. And that language shouldn't be left behind. And that's the interest that I'm defending here. So if it is not in the Constitution, that shows me that Constitution is not my Constitution, and it's not the Constitution of the group of people who are with me. Honourable Speaker, if you come to the uses of medium of communication in the Parliament, we can see they have opened a room. Yes, the language could be used. The national language can be used as a medium of communication in the Parliament. But later on, we have seen that the room has been locked, because it's after 5 years after the coming in force of this Constitution. So if the Constitution is opening a new era, the moment the Constitution begins, all the room open should be used immediately. But that room was open, and later on it's been closed and conditioned. And what we are looking for is our freedom, our linguistic freedom, our linguistic independence. All that we are talking about, democracy whatsoever, it should have a beginning. And the beginning of everything, to my understanding, is our national languages. And if you look at the connotation that I have given to the languages, local, we have been saying that here. Here we don't have local languages. In the Gambia we have national languages. And I think if you are speaking the language of the Constitution, it should be a matured language. It should be a professional language. Because at the end of the day, this is going to be our power to get up and to move. But it's a wrong step. It will be very difficult to have a power to move with this, as far as I am concerned. Honourable Speaker, if you go to citizenship, just calling the attention of the drafter and honorable members that many countries that we know that are today observing or today monitoring political instability is related to this citizenship. Yes, your father and your mother, if they are Gambian, wherever you are born in, you can be a Gambian. But if you go to this extent of a grandfather, grandmother, let us think deep. We are making a very difficult decision. At the end of the day, everything will come back to us. And if you look at the political side, yes, presidential term limit are 2 terms, which I really appreciate. 5-year term, 2 occasions. You leave the place, somebody else will come. But when that will begin, what will bring that? Is when the room is created. And the room is this constitution, this bill, if it is now a constitution. That's the time a new era has begun for the Gambia. That's the time a new language has been created for the Gambia. Any activity related to this constitution should begin when the constitution has become, when the document has become a constitution, and when it is in force. But having a step a step forward and having another step backward, you are moving, but you are not advancing. I don't know the technicality of the language they are using here, but it's important that the Attorney General and the Minister for Justice to help us to understand better. Separation of powers. That's the dictate of the democracy. And of course, why not our civilization? Now you are telling us the powers are separated, but we are telling us each arm doesn't have its own independence. You cannot function without the other. Though we agree that we are interdependent, but our independence also at the institutional level should be recognized. There are certain actions. If they are moved to other institutions At the end of the day, it will bring a confusion. The president can appoint, and that appointment should be confirmed to the parliament. In fact, he cannot appoint, he can nominate. The appointment comes only after confirmation in the parliament. The president is responsible for the executive. The president needs his team, the people he wants to work with, the people who will not betray his trust and confidence in serving the nation. And don't forget that Parliament, yes, is a democratic institution, but Parliament is also a political institution. And don't forget that Parliament do recognize national interests, but also political interests. And we have seen what happened here some months ago, and why that happened. We have seen it. We don't want the same thing to be repeated. If we want to move, let's move genuinely. We cannot move in ambiguity. At the end of the day, the destination will not be cleared. I want to stop here. Honourable Speaker, I thank you for giving me the opportunity. But this concern and many more are in the Constitution. And I'm urging the Attorney General, the Minister of Justice, to help us better to understand. Because at the end of the day, if anything happens, fingers will be pointed to Parliament and the parliamentarians. On that note, Madam Speaker, I thank you and beg to resume my seat.
Thank you. Honourable Member for Woolly West. Thank you.
Thank you. Madam Speaker, I think this is an historic occasion. It is historic because, to my knowledge, it is the first time ever that a constitution is referred to a parliament, the parliament, and is being critically reviewed by parliament. The fundamental difference between this constitution and the 1997 constitution is that even though people were consulted, in the final analysis there was no parliament to refer it to. So a lot of things were distorted. But here we have before our eyes a draft constitution. Anybody who has had an interface with the commission, if you look at the draft, you would see yourself there. In other words, in a sense, we are engaged in promulgating a people's constitution because people have participated in drafting what they think would be a fundamental guide for this republic, either individually or collectively. Those who have been consulted are present in this document. When you look at it, even we who were consulted in Parliament here, and some of us individually had an interface with them, if you look at the draft, you would see that it has taken into consideration what the people have proposed. So that's why it is historic. And here I'm thereby answering a question posed by a journalist. He called me and said, was the 1997 Constitution submitted to a parliament? For him, it was, because he was trying to argue with the honorable member for Serekunda West, who earlier said that it was the first time Constitution is being referred to Parliament. For him, that was wrong. But there was no Parliament in 1997, so the Constitution was not referred to Parliament. So the journalists, please take note that the 1997 Constitution was not referred to Parliament because there was no Parliament. But this one is different. There is Parliament. And that's why we are now here to look at what we have proposed, whether it is here or not. That is why it is historic. Madam Speaker, constitutions are fundamental guides. No country can exist without them, unless, of course, we are a dictatorship. So that's why when they are referred to Parliament, we need to critically look at it to see whether or not it will serve the purpose for which it was drafted. Whether there is a need to improve upon what has been submitted, or whether there is need to delete what has been drafted, some part of what has been drafted. That is the job that we are engaged in doing. And that's why this section that Madam Speaker was quoting is relevant. Some think that we have no authority to do anything like that, but that's what the law provides. That's our fundamental role. I will look at some sections of some clauses of the Constitution. You may not call them sections because it's not yet enacted. When it becomes law, we have sections, but here we have clauses. Some of the clauses I refer to, I will deal with them more in detail when we come to committee stage because they have to do with language, formulation, and some of the things. So, like clause 3, which talks about the territory of the Gambia, and this is excellent. The 1997 Constitution does not talk about the Gambia for which it was made. It did not define, it has not defined what the Gambia is. But here, in this draft, Gambia has been defined in terms of territory, in terms of space, in terms of water. It's here in this Constitution, which is beautiful. Because the Constitution is about the Gambia. So that Constitution must define what the Gambia is. If it doesn't, then you have a problem. That was the big limitation in the 1997 Constitution. But in formulating that here, I have some problem, but I'll just pass them. When we come to committee stage, I'll deal with them. And the same thing goes for clause 5. Clause 5 is on the decentralization. Yes. Yes, decentralization. Clause 5(2) says a state organ shall ensure reasonable access to its services in all parts of the Gambia. You know, I have a problem with the phrase reasonable access. And the same thing is for clause 5(3), where local government shall ensure reasonable access to services. I have a problem with the expression reasonable access. But I'll talk about them in detail when we come to committee stage. And then, of course, this is, the Honorable Member for Basse has already talked about it, clause 5(4)(e). We don't talk about local language. This is the colonial expression of our languages. Colonial terminology for our language, local language. What is local language? We have national languages. Each Gambian language is a national language. We don't have local languages. Please stop calling our languages local language. They are not local, they are national. And that is why the honorable member is absolutely right, that the Constitution should define what these national languages are. Because the same Constitution is saying that we can use these national languages here. So they must be defined. What are these languages? The Constitution should tell us what these languages are. Otherwise, what are we going to do? They should be here. It should codify this language and say the national languages of the Gambia are A, B, C, D, A, F, up to Z, if you please. But that does not exist here. They have had passing references to what they call local languages. This is inadequate. We are moving towards proper liberation of our people. And that cannot be without a linguistic liberation. We are fettered here in this National Assembly. We should remove the chains of our necks. Because we are chained, linguistic chains on our necks. Those we represent don't understand what we say here. That is why this Constitution is making it necessary. Although I don't agree with some of the expressions that they are talking about. But it is absolutely necessary that we begin to speak the language of our people we represent. The Constitution must make that an obligation. Otherwise, where is our freedom? Where is our identity as a people? Without language, we don't have any identity. The more we speak English, the more we are promoting and developing English to the detriment of our national languages. This is what must stop. And that is why I'm saying, I don't agree with the Constitution when they are saying within 5 years. Why 5 years? Why 5 years? Why do we, after 55 years of existence, we are still talking about using our languages, preparing for 5 years again? Why? That is not helpful at all. Enforcement of the Constitution, clause 9(4). Well, here, also there is a linguistic problem here. I'll leave it until when we come to committee stage. I'll deal with it. Same goes for 13.3, clause 13.3. I'll deal with it. Now, Madam Speaker, we have been grappling for 55 years with a fundamental issue, which is citizenship. Who is a citizen of this country? We have been grappling with that. And it seems we still have not found a solution. Because if you are telling me, if the Constitution is just saying that if you are born in the Gambia, any child born in the Gambia automatically is a Gambian citizen, for me, I have a problem with that. The Gambians like to enjoy international standards. What is internationally valid, Gambians want to enjoy that, but they don't want to reciprocate that. We know that Gambian women leave this territory. They have never been to France, they have never lived in France, they have never lived in the United States, they have never lived in England, but they go there pregnant to have their children in order for them, their children to have that nationality. We know that. This is happening here currently. Why can't we reciprocate that? We are enjoying that, our people are enjoying that, and we don't want to give that possibility to other people to enjoy. People have been living here for 40 years, 50 years, all their lives. Their children are born here and they are not Gambians. This is terrible. They have been paying all sorts of taxes here for decades. And yet the children they have here are not Gambians. And they were born here. Where should they belong? They belong where they were not born? That's not correct. A child can acquire the nationality of wherever he or she is born. That's what is international standard. Even if a child is born in an aeroplane over the Gambia, airspace, automatically that child is a Gambian. Should be a Gambian. If a guy is born in a ship in Gambian waters, wherever that child is from, if he or she wants to be a Gambian, he should be given that possibility to be a Gambian. That should be the law. Anything else short of that, for me, is not adequate. So we should stop grappling with this. We should not be third-setting, because we are already enjoying this from other countries. So let us reciprocate. People have been living all their lives here, and their children are still non-Gambians. That is not correct. We should not allow people to be stateless. That's a crime against humanity. Clause 19. C. Now, clause 19.3c is saying the age of the person becomes known and reveals that the person was older than 8 years when found in the Gambia. So, you know, it is about a child who is found and is supposedly about 8 years, is granted Gambian citizenship. But if later is discovered that he or she is more than 8 years, it's negated. That's exactly what I was talking about. We are talking about a child who is found and whose parents you probably don't know, and then you say, if he is 8 years, suppose he is 6 years, suppose he is 5 years, suppose he is even 3 years, or even 6 months, because we have all that in this country. So what do you do? If it's less than even 8 years, let's say 6 months, or even few weeks, so such a child will be stateless. Is that what it means? We are talking about 8 years, but there are children who are dumped, whose parents are not known at birth. So what do you do with such children? Are they Gambians or are not Gambians? Because we are now talking about days, not even weeks. I think there is a need for us to look at that more seriously. And clause 26. This is very interesting. These are some of the innovations in our Constitution. Clause 26 is talking about a gift to a public officer on a public or official occasion or on account of the office he or she holds is a gift or donation to the state or the institution he or she represents and shall be delivered to the state through the Anti-Corruption Commission unless the gift is otherwise exempted, which conditionally or unconditionally by an act of the National Assembly. Well, this is a law in some countries, and I know in a particular country, the president was imprisoned because of such a thing.
Honorable, sorry. I stand to be corrected, but if you're reading from the section dealing with gifts, your mic, otherwise you won't hear. Yes, thank you. Dealing with gifts, yeah. It's something that came up, but don't you think that it deals with, to a certain extent, details? If we are reading it, can it be broadened to cover the principle behind it? And the merits or demerits of that particular clause.
36 is about financial probity of public officers. That's the heading. I think the whole principle of this is that public officers, whatever they are giving in their official capacity, should not belong to them, should belong to the office or the state they represent. That's the whole principle is simply that. I'm saying that this is a law in some other countries, and I know somebody who was imprisoned for taking such a thing, a gift given to him, instead of giving it to the state, because it was given to him as a president. And I know also somebody was given, a president was given a vehicle and took it. But then the problem is, I think this is a good provision in our constitution, that when things are given to us, like if I go to somewhere and certain things are done for me, they are not done to me as Sidia. They are done to me as Sidia representing people. And that which is given to me in that capacity belongs to the people I represent. That means it should go back to the state. I agree with the principle. But the enforcement is the problem. Like, I will come to that. The enforcement is going to be the problem. Limitations of fundamental rights and freedoms, clause 36. Well, here, I'm glad that the National Assembly is involved. Otherwise, I would say that the National Assembly should be involved, because how do we control the excesses of an autocrat? But it is here, the National Assembly has to make a law to that effect. So it's fine. Now, clause 57, which is very important in the sense that it is in the 1997 Constitution, but 1997 Constitution is how many years old now? 20-something years old. And the provision has not been implemented. So it's not enough for us to have things in our laws only for them to die there without being implemented. That's the right to education. Clause 57 is saying, like the 1997 Constitution, all persons have the right to equal educational opportunities and facilities, and with full realization, that's right, basic education in the 1970 is supposed to be free but compulsory. It was neither free nor was it compulsory for the years that we have been having this constitution. So I only hope that we will not have this again in this draft when it becomes a constitution, only to be like the 1997 constitution. It is here because it is meant to help develop. It is meant to serve the people. But if it is not applied, then it will not serve the purpose for which it is drafted here. So that's my problem. This is in the 1997 Constitution, but it was never applied. Because education has never been free here. No one will convince me that we have had basic education free here. I've been paying school fees for people in basic education. So nobody can convince me that it was free. It has never been free. But the law is said, I raised it in 1997, and what the minister answered was, we don't have, I say, but what are you doing? We don't have the means. And the law is saying that it is mandatory for children of this country at that level to have education free, but compulsory. So there is no question that the resources are supposed to be there, they are there. That's why the law is saying that it should be free. And that's why the other ones are not compulsory, they are not free. Progressively we are moving towards making them free, but they are not free, but the basic education should be free. And here also it is indicated. So the problem is, it is not enough for us to make laws, but we must have the mechanism of implementing those laws to make them meaningful. If you don't do that, they are useless. So that's the problem here with this clause 57, which is almost a repeat of 1997 Constitution section on this. Now, let me (49). Clause 49, freedom of religion and conscience. Now, 49.3, for me, is the formulation is weak, and it is not supposed to be weak, because what it's saying is, 49.3 is a person may, the word may is what I'm underlining. A person may be denied access to any institution A person may not be denied access to any institution, employment or facility, or enjoyment of any right because of the person's belief or religion. The word may should be replaced with shall. For me, this is fundamental.
Honorable, that's why I appear to tend to have an issue. I am not agreeing or disagreeing with your suggestion, but I am saying that it appears as if that is going into the details. Don't you think that to change that word from may to shall should wait for if we get to the consideration stage? Yes, that's my point. Thank you. (57E), 57(1)E is saying tertiary and higher education shall be made equally accessible to all on the basis of capacity basis of capacity by every appropriate means, and in particular by the progressive introduced, like I was saying. But what is of concern to me here is D, clause 57D, 1D, 2D rather. It says functional literacy shall be encouraged and intensified as far as possible, and the development of a system of schools with adequate facilities at all levels shall actively, like they're saying shall be encouraged. This should be undertaken by government as a matter of necessity. Functional literacy. It should not be left like it is here. It should be undertaken seriously, because very soon, if you mean business, very soon we'll be dealing with only with our languages. English will just become functional when we are dealing with the outside world. But internally, we'll be when we are dealing among ourselves with matters, we use our own language, which means that functionality is an absolute necessity. The surprising thing is, before, in the 80s, in the 70s and 80s, it was very strong in this country, but it has died out.
I don't know any institution which is now running functional literacy classes in this country. And the Constitution is making this very important. So it is not a matter of encourage, but the government should undertake to promote functional literacy among the people of this country. That is the only way we are moving towards development and liberating the minds of the people and our own minds. This National Assembly itself needs to be re-educated for that matter. Particularly when you talk about cultural rights, there is the fundamental thing in culture is language. If you miss language, then you miss everything else. So when you talk about cultural rights, language is number one. And that is why since 1953, UNESCO made it an absolute necessity for every child in the world to have the first stages of education in the mother tongue. Since 1953. And we are still here conversating with all these problems that we have. Unless we stop conversating, this language issue is fundamental to our development, is fundamental to our identity. So we must take it up seriously. Otherwise, we will not go anywhere. And that's why we have been groping in the dark for the last 55 years. We are just turning around because we have not been free culturally. I know the Environment Committee would be very interested in this clause, and maybe they will say a lot of things about it, because if you talk about the right to a clean environment, currently any from here, Banjul, the capital, move to Serekunda, how is the environment like? Polluted? Rotten? No cleaning up? People have to dip into their pockets to pay for people to come and collect their refuse. So the whole place is dirty. When it rains, every place is smelly. So what is the role of the councils? What are the councils doing about the cleaning up of their environment? Let's go to have these provisions, but then I say again, implementation. How do we ensure that these things are implemented to serve the people? That's the issue. We have them beautifully written, but they never see the light of day. I think the important thing is to ensure that this happens. And the same thing goes for some of these things will be dealt with when we come to. But let me come to something which is I've been thinking about since day one. The nomenclature that they have chosen for the IEC, Independent Electoral Commission, is called here Independent Boundaries and Electoral Commission. I'm not comfortable with it. It does not say exactly what we want. First, there are no independent boundaries in this country, and the emphasis of independence seems to be placed on boundaries. And the emphasis of independence should be placed on IEC. Independent Electoral Commission is what is important. I think the best way to do this is to call IEC Independent Electoral Commission and make constituency boundaries demarcation one of its supreme functions on the IEC, and let us remove it from the name, because in fact it is not named there, because independent boundaries, it means nothing. You don't have independent boundaries, so why do we have independent boundaries? They either have to say constituency boundaries, but independent boundaries don't exist. So why do we have it in the name? I would propose that we have independent electoral commission and demarcation of constituency boundaries be one of its supreme functions. You put it under it as a function, not to be added to the name, because it is confusion. And to finally, qualifications for the president. Clause 93F. Yes. It is stated here, clause 93, that one of the qualifications that the person concerned holds a minimum of an undergraduate degree plus 5 years work experience. I agree 100% with that. But the next one is what I am questioning. Holds a minimum of senior secondary school certificate or its equivalent plus, 12 years work experience after. You see, as long as we continue to take English as our official language, as long as we continue to use it in matters of officialdom, then it is absolutely necessary that the head of state of this republic is highly qualified in the use of that instrument. If not, we have a problem. I have seen it in the old parliament and in this one. Even where they are briefed, it is difficult for some people to grasp the essence of what is being debated or what is to be said. So the mastery of language is fundamental. You are in this country. Some of us have been teachers, many of us here have been teachers. You know that currently the situation in the Gambia, even grade 12, somebody who can speak fluently English, grade 12, and can write fluently, it's difficult to come by. And there are many Johnny just comes in our politics. Johnny just comes who would want to be president, just like that. And they have possibility to become president. Because people don't look at qualifications. And if a Johnny just becomes a president who does not know how to speak English, then we have a problem. When he goes to the United Nations, are you going to stand behind him and be speaking for him? No, or her? Are you going to draft his speech or her speech on the spot in the United Nations Hall? Impossible. So you must have the capacity. And that is why I agree with the first one, F. But G, I question. I think we should have much more than that. A president of this country should have much more than just a grade 12. It is an insult to a republic. That happens in situations we are not in that situation. I can give you situations where the presidents are not necessarily graduate, but they are fantastically intellectual. But they have grown themselves. They have developed themselves. They came from certain experiences, and because they knew they were going to assume such functions, they prepared themselves. We don't have that in this country. So, I, for one, I would not go for G. F, fine.
But I don't like interrupting or disrupting your interventions, but again, these are valid points for consideration.
I'm raising them, but we'll come with them, madam.
You've given the outlines, the various details, very good. But the details, I think, are for sorry, consideration state.
You have been consistently stealing my time. So I'm going to add more time. Huh? Okay.
Please.
Okay. Clause 157(1). 157(1).
Interrupting, because for me, once I get interrupted, I tend to lose my train of thinking, but I just had to interrupt.
So you are
I'm
deliberately
sorry.
doing that to mix up my thoughts. This is not, it's
I'm
not
getting
fair.
old.
Okay, it said the business of the clause 157(1), the business of the National Assembly shall be conducted in the English language or in any other language indigenous to the Gambia. So, you see how important our languages have become. And that is why it is fundamentally important. What I was saying about, you say, encourage. No, it is an obligation now for government to assume that responsibility. Because these languages, and then this constitution has not gone to its logical conclusions on this particular provision. Because there are two forms of literacy in this country currently, madam. There are people who are literate in an alien language, which is English. And there are people who are literate in their own languages. And this constitution is now saying that those languages can be used here. The logical thing is that anybody who is literate in these languages is also entitled, eligible to become a member of this National Assembly. That should be the logical thing. Anybody who is literate in a Gambian language, I know most of us here are not literate in Gambian languages, but we are here by virtue of being English speakers. But the law is now saying, if you want to speak your language, you can speak it here. And we already know that there are a lot of people in the country who are literate in Gambian languages. They are citizens, they have a right to representation. So the constitution should have provided that anybody who is literate in a Gambian language is also eligible to become a member of this parliament. For me, madam, that should be the logical conclusion on this particular provision here. Anybody literate in any Gambian language has a right to become a member of this National Assembly because he or she has a right to speak in a language of her choice here, which is Gambian. I think we must promote that. If we don't do that, we are not fair to the people of this country. I'll stop here for the time being. The rest I'll deal with when we come to committee. Say thank you.
Thank you very much. Honorable Member for Jara Central. Jara Central, thank you.
Thank you very much, Honorable Speaker, for granting me the opportunity to also throw my light on the bill that we have before us this morning, which is the Draft Constitution 2020 of the Republic of the Gambia.
Sorry, Honorable, before you proceed, just allow me. I just want to get my records right. Did I get the Honorable Member for Sabiji? Was it Sabiji or Upper Fuladu? Who raised the time? Okay, then I'm right. Thank you. You can proceed, yes.
Honorable Speaker, as I was on my foot, first of all, I would commend the CRC, which is the Constitutional Review Commission, for inclusion of certain clauses which has never been in the 1997 Constitution, which ranges from the presidential term limit, inclusion of the, any national language to be used in the National Assembly, in the Gambian National Assembly chambers, so on and so forth. Honorable Speaker, however, there are also issues that I definitely, when I saw them in the draft, in the 2020 draft constitution, I started thinking twice, Honorable Speaker. The constitution of the draft constitution, Honorable Speaker, started with a clause, most preferably clause 7.3, which reads, Honorable Speaker, if you might allow me the opportunity, the validity or legality of this constitution is not subject to challenge by or before any court or other organs of state. Honorable Speaker, when the CRC was going around the whole country, I could fully remember the words that they were saying is that anything we put in this draft 2020 constitution would be the view of the people, of the Gambian people, for that matter, not any person, but the view of the Gambian people. So, Honorable Speaker, if anything that this draft 2020 constitution contains is the view of the Gambian people, this clause that this constitution is starting with definitely is a thing that somebody should have to think of. If the Gambian people, their opinion is what is being put in this draft, yet they do not have the mandate, even whereas they are innocent of certain clause or certain section when this bill is being passed, they have no mandate to challenge it in court. Honorable Speaker, it is something that we have to think of. Personally, I myself, I have to think of this very, very passionate.
I'm looking for the clause that you referred to. Can you help me, please?
If you go to the draft, Honorable Speaker, the final draft, yes, the bill.
That's the section.
Okay, the bill.
Section 7. Yes, because I think you said section 10.
No, I said 7.
7.
I mean clause 7. Because it is not yet passed, so this is why I'm using the word clause. 7.3. Have you seen it, Honorable Speaker? May I continue, Honorable Speaker? Yes, thank you very much. It's a cause of alarm, Honorable Speaker, to me and the people that I represent, because if somebody is being confronted among my constituents and happens to be involved in any other issue where it has to involve court, and he is innocent in so doing, he will not have any legality to challenge this constitution. So therefore, Honorable Speaker, it's a cause of alarm for me. Honorable Speaker, we have been trying to open a new chapter in democracy, the Gambia, for that case. In so doing, Honorable Speaker, the draft should not have started with a clause of this nature. it is definitely inconsistent with the rule of law. This clause is inconsistent with the code of with the rule of law. And definitely, what we have to understand, Honorable Speaker, is that the Constitution is not equal to the 10 Commandments of God. The Constitution is not equal to the 10 Commandments of God, Honorable Speaker, because these things are made by human beings, and we all know that no human being is perfect. We can change it anytime we need, when the need arises. And we can add anything when the need arises. I'm just trying to buttress on that clause, Honorable Speaker, of which this draft is starting with. So, I cannot take this to be the 10 Commandments of God. On that being the case, I think that clause, something needs to be done about that clause. Honorable Speaker, when you go to the confirmation of judges, section, if you go to the confirmation of judges, Honorable Speaker, section 190, Honorable Speaker,
the principles and the merits,
yes,
not the details.
Exactly. Honorable Speaker, confirmation of the judges of the highest court of the Gambia, I think, is in this constitution is subjected to the approval of the National Assembly. If we pass this, that's what will happen. So any judge of high court that we are going to hire, his issue will be brought to the National Assembly for confirmation. Honorable Speaker, my fear here is that the issue might be politicized. We have seen what has passed during the last session. So this issue also, or that clause also, Honorable Speaker, need to be looked at very, very, very carefully. What a surprise was to me, Honorable Speaker, is that the CRC, in some instances, while drafting this constitution, the 2020 draft, would just go directly and cut from the Kenyan constitution and paste. I'm not disputing the fact that they can go and make their research on various countries as how they work, but Honorable Speaker, cutting and pasting was not the reason why we instituted CRC in 2 years ago. We tasked them to go around the whole country, ask the view of the people, get it on board, try to see how to incorporate them into a constitution. But, Honorable Speaker, instead of that, the clause that I have just quoted for you where this constitution started with is just a cut and paste from the Kenyan constitution, 2010. They could have made some amendments. There's no problem. But cutting and pasting, and you call that the view of the people, of the Gambian people? Honorable Speaker, I say no. So many of these drafts here, many issues are here, are not view of the Gambian people. It's just a cut and paste from Kenyan Constitution, 2010. On that note, Honorable Speaker, I beg to take my seat.
Thank you very much. Honorable Member for Bundunka Kunda. Bundunka Kunda, yes. Thank you.
Thank you very much, Honorable Speaker, for giving me the floor. Honorable Speaker, it was December 2017, we passed an act to enable the CRC to review the 1997 Constitution. And early 2018, the President assent to the act. And June 2018, the members of the CRC were appointed. And it was on the 15th of November 2019, CRC prepared a draft new constitution. And it is brought to us back. We gave them the mandate, and we are here today to speak or to debate on the merits and the general principle of that draft constitution. Therefore, Honorable Speaker, this is a crucial moment in our role as a National Assembly members, because we are in a transition. And a lot of things has happened in the past which we are not proud of. And it is only when we come up with good laws we can redress some of those issues. So, this is a very historic day for us, and we are here not representing our people, ourselves only, but representing our people who voted for us to come here and represent them. And the mandate given to CRC was to go around and engage every Gambian at every corner, even outside the Gambia, to engage them and incorporate their takes on this new constitution. And we believe the CRC has done a tremendous job by going all over the country, the length and breadth, meeting all categories of people to sound their opinion, how they want to be governed. Honorable Speaker, this draft constitution before us today is one of the most important documents for our democratization. It is important because in any transition of a good democracy, it requires a social contract between the governing and the governed. This was the mandate that was given to them. Therefore, Honorable Speaker, at this juncture, when we said we want a new Gambia, we had two options. One was to amend the draconian laws that were bad, very bad, that were in the Constitution, or two, to revoke the existing one, that is the existing Constitution, which we went for. And now the draft Constitution is in front of us here today. We all know that making a new Constitution is very difficult and complex. This is why I want to thank CRC for their tremendous job that they do to make sure that they went through numerous processes and make consultation to make sure that they have agreed to a common laws that different Gambians give their opinions to make sure that everybody's opinion or the majority's opinion is put on board. Honorable Speaker, we really want to break from the past. So I think this draft Constitution is the best document to lead us into our new democratization we want. After reconciliation, we need this draft to address social redress. We might have issues about this Constitution, but we should realize that there is no one Constitution that can favor everybody at a time. What is important is to look at it critically and see ourselves both in and out, to make sure that it will be good for our people, that is the citizens of this nation. It is not for ourselves, but it's for every Gambian. We all know a lot of money is invested in it, a lot of efforts, and it has been sanctioned by us. Then definitely we should try and make sure that we give our blessing to the views or how Gambians want to be governed. Honorable Speaker, I always advocate for the autonomy of this parliament since at the inception, or since we came here. I had my reasons. In order for us to perform our oversight function properly and the way it should be, I think the National Assembly should be autonomous. Since we came, we tried a lot, but some of our efforts were hindered simply because we are not autonomous. And this draft constitution has come to make this National Assembly to be autonomous so that it can perform its oversight function as the way it should be. Most of the time, the whole country rely on this National Assembly when all hopes are lost. But sometimes what normally happens is we are not able to perform up to expectations because we will be told that we need to have confirmation from the executive to be able to do certain things. Therefore, Honorable Speaker, this draft constitution has highlighted a lot of issues that will help us to break away from the past, which we all know that we are not happy about, both those who are in and those who are out. And since we are all here now, we have a decision to make and we have a history to make. We can either be in the good side of the history or the bad side of the history. So it will be important if we consider what or how our people want to be governed. And I believe there are a lot of things in this draft constitution that are very good to help us break away from the past and bring a lot of rules or laws that will help us to have a very good Gambia. Honorable Speaker, the Constitution or the draft Constitution highlights the devolution and the decentralization of the local government. In the past, we have a lot of institutions, good institutions, but there were not enough laws to be able to help them to perform up to expectation, to perform as how they should. But we could see that this constitution has really come to help the institutions to function as they are expected, to give them necessary powers in order for them to operate as they are expected to do. And, Honorable Speaker, in Africa, our problem is leadership. Many, many years, we trust our leaders, but they end up failing us. And this constitution, one thing I like about it, most of the bone of contention, it has come to clarify or remove all ambiguity that will bring commotion or that will bring ambiguity that may bring problems for us. For instance, that is the 2-term limit and how does it start. Honorable Speaker, with all fairness, I think if we want to advocate for 2 terms, I think the best thing is for us to start with a good example. I'm surprised to hear some of my colleagues to think that, or to say that, the incumbent who is in the office before the Constitution will come into law, the term that he served before the Constitution should not be counted. Yes, it could not be. That is obvious. But if that is what we are advocating for, I mean, I think it is in fact better for that person to start with a good example so that we know that we really mean what we are saying. But often a time in Africa, this is how it all starts. At the beginning, if we are not very much attentive, some will say, we are here for 3 months. They go for 2 months. And while they are going, they want to remain in power forever. I think rules are what should help us to redress all those problems. And to be a good example, or if we are to mean what we are saying, I think we should start initially, or whoever start. But most often a time, those incumbents who started that, who will start that, we will see as we are going, they will start to think about, in fact, not 2nd term, but 3rd term, 4th term. I mean, Africa should break away from that right now. And African leaders are the people who should help Africans to break away from those mentalities. Because people trust them to be there. So, Madam Speaker, with all honesty, the CRC did a wonderful job to come up with this draft constitution. This draft constitution, these are the wishes and the aspiration of Gambians who we represent here. The CRC doesn't make this constitution by their own. They contacted our people, and a lot of resources is being put to it. We cannot come here today and allege that they merely went to cut and paste from other constitution for this draft that we have in front of here today. I think they should be commended for all the tedious work they did, for their country. And when I went through it, I really think that they did this for love of their country. We should all remember where we are coming from. The past was not pleasant. We want a better Gambia. We want a better future. We want a good democracy in our country. Then we should start good. We should set good examples. We should not bring anything that will bring any commotion or any misunderstanding between us now. All what we should see is Gambia. Nothing else but Gambia. Not ourselves, no an individual, but Gambia and Gambians. Honorable Speaker, if we look at Chapter 1, that talks about the republic and sovereignty of the people. It has addressed a lot of issues that can help us to see ourselves as Gambians. To help us to come together. To help us to be strong. Because together we are strong. We will be unbreakable. Let us not allow ourselves to be divided. It has talked about all the different backgrounds of our people, faith, culture. Form of discrimination, sovereignty. This is very good to help us, and it should start here. See ourselves as the National Assembly of the Gambia, representing the Gambian people. Not to have a master to serve. Our master should be Gambian people. They are the people who put us here, and we should be ready to serve them. And they have hope that it is us that can help to make Gambia one people. And we should all be ready to work towards that. And the laws in this draft constitution will help us in a great deal to achieve those goals. Though there are some issues that we can fine-tune to make sure that there is no even small ambiguity. In other countries, in the past, we saw small ambiguities in their constitutions have bring chaos and commotion because they are not spelled out. Many of those issues are categorically spelled out and clear in this draft constitution. It's only the matter of going through it, and the ones that we feel are not fine-tuned, we try to look at them and fine-tune them so that there will be no other ambiguity in this constitution. I think that should be our great role. This is very significant. we have an opportunity. The opportunity is our hands now. And it is left to us. It is like an egg in our palms. If we drop it, it will spoil, break, and we cannot use it, we cannot eat it. But if we take care of it, we can use it to benefit all of us. Therefore, Honorable Speaker, I will want to stop here and once again thank CRRC, the President of this country, and my colleagues, Minister of Justice, for coming this far to have this draft constitution in front of us. I will then save my other comments to when we reach into the Committee of Full Supply, where we can fine-tune some of the issues that we have. Thank you very much.
Thank you. Thank you very much. Honorable Member for Brikama South.
Thank you very much, Madam Speaker, for giving me this opportunity to take part in this important function today. First of all, Madam Speaker, I would like to specifically thank the President and the Executive for their foresight and coming out with this Constitutional Review Commission, which was further approved by this very National Assembly to look into our current Constitution, the 1997 Constitution, and the wrongs that have been done in the past that are legally supported. If you look at it, Madam Speaker, almost the entire Gambia unanimously agreed for this Constitutional Commission to come into force. And it's very important, and this is very important for us to participate in this process as a historic moment for the country. Madam Speaker, our collective action in establishment of this Constitutional Review Commission has been justified in the various commissions that have been established in this country, and that is also approved by this very National Assembly. If you look at the 1997 Constitution, you have laws that are ill-conceived and obnoxious in nature. Some of them are repressive. And this has given an opportunity to some of the public officers to be legally offending one another. So the new draft comes specifically to address those problems. If you look at it clearly, Madam Speaker, the draft constitution seeks to address and promote the principle of good governance, which is very, very key here. And if you look at it, the actual empowerment of the oversight institution, that's the National Assembly, which I believe no country can rapidly develop in the absence of the empowerment of this institution. Madam Speaker, if you look at it, there is another principle which is very, very important in the draft, that is talking about parliamentary approval of the appointment of the cabinet ministers. I think if you look at the public service here, things start from that aspect, which is very, very key. In the 1997 Constitution, the ministerial appointment are political appointments, and those ministers happen to be policy advisors to the president, and the head of
their respective ministries, which is very, very key. But one thing we have experienced in this country, many a time if an issue emerges in the country that has attracted the national attention, you will understand that if some of these ministers express an opinion that is contrary to the political wish of the president, they are sacked. And this has created insecurity for a lot of the ministers. And over the past, that is why some of them has to succumb to the political aspiration of the president, even on the detriment of the country. So that aspect has really affect the public service in the country. And almost all the senior cadre in the public service. But the draft seeks to adequately address that, which I am very much happy. And I think for a start, we'll be able to be on a very firm footing. The other important aspect is the complete autonomy of the local government in this country, which is very, very, very important. And we have to look at it in that dimension. The local governance is something that has been seriously struggled in this country because of the control. But the autonomy of that is another principle that we need to cherish as a country. And the Constitution also addressed that. If you look at the local government previously, the elected chairmen are always answerable to the various governors in the region. And if you look at those governors, they are also representative of the president, political appointment. The chairmen or the mayors are appointed, they are elected by the people. So you always have this fracas between the two, which really affect the performance of the local governance. And they were the approving authority. But right now in the draft, you will be happy that it's adequately taken care of. And the parliamentary financial autonomy, which is very, very key. If you look at that one, Parliament is one of the most important organs, not only in the area of legislation, but the oversight aspect, which is very, very key. So if the autonomy is there for them to operate and conduct their business on time, I think that one will definitely give a lot of improvement in our different activities. Honorable Speaker, I definitely want to give my blessing. I didn't want to go further, though there will be no constitution that can serve our interests 100%. We have some issues when we go to the Committee of Supply, we'll be looking at that. But one thing I want to urge the National Assembly, this is our own initiation. We approve this to come into play. And I definitely want to thank the CRRC for making a nationwide consultation across all sectors of life, in and outside, even Gambian outside are consulted. And this is the views and the aspiration of the people, even if it is not adequately captured, but it has captured almost all. All the sector, the National Assembly, the Executive, everybody is consulted. And this is what is compiled and contained in this book. So right now it is before us. Parliament has a huge responsibility. We either pass this or we reject it. And this is where my concern is coming. And I will urge all the National Assembly members to pay a specific attention and make sure that we pass this thing. After fine-tuning the way we want it, we must pass these things because it's important. Remember, it's perchance we are here, but it doesn't mean that we are better than the larger public. So this responsibility is bestowed on us, and history is going to judge us. We approve this commission to work on nationwide engagement to come out with the draft where taxpayers' money has been committed, up to 116 million. That's a huge amount. If we should reject this thing, what are we telling the population? So this is the area in which we have to look at it critically and make sure that if we have any observation, we'll go to the Committee of Supply. Let's look at it clause by clause and see how can we fine-tune it to better represent the interests of the people. And again, if you look at the 1997 Constitution, from 97 to today, it's almost 23 years. Most of the clauses are obsolete. They don't commensurate with the current realities. And for a start, that is why I'm specifically thanking the President and the Executive for coming up with this initiation. Because we cannot do anything in this country without going into our books, repeal what are obsolete and obnoxious, to make sure we bring in what will represent the realities. And that is before us. From this, we can go to the various acts too, that govern our sector operations, which are very key. But that cannot be done without the new constitution coming into the force. So I am appealing, I am 100% in support of this thing, even whereas we are going to make our own fine-tuning at the Committee of Supply. But I want to appeal to each and every individual to make sure that we pass this constitution and get into the Third Republic of this country. On that note, Honorable Speaker, once again, I want to resume my seat and thank everybody for listening.
Thank you, Honorable Member. May I now call on Honorable Member for Serakunda. The floor is yours.
Thank you, Honorable Speaker. We are engaged in nation building. We are here to prepare the architectural sketch on which the foundation of the nation must be erected. Honorable Speaker, Section 101 of the Constitution, subsection 2, states that no bill except a particular kind of bill shall be introduced into the National Assembly unless it is accompanied by an explanatory memorandum setting out in detail the policy and principles of the bill, the defects which it is intended to remedy, and the necessity for its introduction. Honorable Speaker, our Standing Order 64 states that every bill shall be accompanied by a memorandum signed by the person in charge of the bill, containing a statement of the objects and reasons of the bill, including the nature of the issue the bill is intended to address, the main options considered, the consultative processes undertaken, and the rationale for the approach taken in the bill. A statement of delegation of legislative powers and limitation of fundamental rights and freedoms, if any, an indication whether it concerns regional government, and a statement of its financial implications, and if the expenditure of public monies will be involved, should the bill be enacted, an estimate, where possible, of such expenditure. No bill shall be introduced unless accompanied by the memorandum referred to in paragraph 1. Honorable Speaker, a bill is before us. The Constitution of the Republic of the Gambia 2020 Promulgation Bill. It has an explanatory memorandum stating the objects and reasons that this bill seeks to promote for the promulgation of the Constitution of the Republic of the Gambia 2020 and to repeal the Constitution of the Republic of the Gambia 1997. Yes, the mover of the bill, the motion, The person in charge of the bill could have extended the objects and reasons. But do we need that? This bill is a byproduct of our own actions. We passed the bill that gave rise to the Constitutional Review Commission Act 2017. We are very clear what we wanted the commission we made to come into being by the act that is our handiwork. Honorable Speaker, Section 6 states very clear the functions of the commission are to draft a new constitution and prepare a report in relation to the constitution. Here is the report. And you look at their report, they've explained all the elements that are required by Standing Order 64. And what is amazing, Honorable Speaker, is that the report gives us references of the consultative process, the literature review that they had undertaken in order to come up with the draft. And part of the references that I can see, 32 Malawi Citizenship Act, 33 Malawi Constitution, 34 Kenya Constitution. Plagiarism is to quote without making reference and ensuring that you give authority to where authority is due. This parliament is not an ordinary institution. Outsiders cannot come and stand here and speak. Before we make allegations, we must make sure that they are situated in truth. Otherwise, we're undermining the integrity of this National Assembly. Honorable Speaker, we have said we charge the Commission with these responsibilities in carrying out its functions under subsection 1 of the Constitution, seek public opinion and take into account such proposals as it considers appropriate. Considers appropriate, that has content, form, and context. You cannot consider any matter without checking the context. What are you able to do? And you have to make reference to time. How much time do you have to do it? All this matters. So if we are to gauge, we must gauge based on those standards. Honorable Speaker, it says that they must review the 1997 Constitution. So if you find provisions of the 1997 Constitution embedded in the draft, that is what is supposed to happen. If they are convinced that those provisions are authentic and should be there, that's the duty you've given them. That they must adhere to the national values and ethics. They must safeguard and promote the following matters: the existence of the Gambia as a sovereign independent state, the supremacy of the sovereignty of the Republic. What is there in the first chapter? It's talking about what? The sovereignty of the Republic and the sovereignty of the people. That's what we have asked them to do. That's the principle. Honorable Speaker, it says that they must ensure that the existence of the Gambia as a sovereign independent state must be asserted. The Gambia's republican system of governance, including its democratic values
and respect for and promotion of the rule of law and fundamental rights and freedoms. Honorable Speaker, if you look at the whole draft, you will see the provisions. Clause 11, national values and principles. Clause 85, guiding principles of executive authority. 134, principles of parliamentary governance. 238, principle of decentralization. And then 203, principles of decentralization. 238, principles of public finance. 171, principles of justice. 283, principle of national security. So everything that is there embedded in this constitution, in the draft, lie on a foundation of principles. Principles can be mere ideas, but it can also be concrete law. And that's what they have sought to do, to provide the principles and then make the law, so that you know why the law is there, for us to be able to gauge whether they have actually served us in the right way. Honorable Speaker, it mentions the separation of powers, national unity, cohesion, and peace, the importance of ensuring periodic democratic elections based on universal adult suffrage, including the introduction of term limits for serving in the office of president. We instructed them. This is an instruction. The Gambia continued existence as a secular state in which all faiths are treated equally and encouraged to foster national cohesion and unity. We are all sovereign. We own the Gambia. We are all voters. We belong to different religions. He said that all faiths must be respected. Imagine the debate that this generated. People talking about everything in the sky except what a constitution is. And what the constitution is a mundane instrument. You look at the 1965 constitution. What is there? That executive power lies in Her Majesty. Is that from above? In which religious book would you find that? That's a mundane instrument. We move away from that up to the 1970 Constitution, giving you the authority to determine your manner of existence. To the 1997, and now we're thinking of moving forward. It moves qualitatively from one stage to another. That's what development is all about. So we are here today about development, Honorable Speaker. That's the object. The object is to move forward. And we must ask ourselves the question, do we have the instrument that can help us to move to the next stage? We'll continue to move to higher and higher stages. We will never get there because development will always be higher and higher stages. So the context must determine content and must determine form. The context in which we are in, Honorable Speaker, is that we inherited a 1997 Constitution. We've been using the Constitution. You can see how much it has served us to be able to vet appointments up to the Office of Ombudsman. We rejected. You can see then the powers we have under the Constitution. And because of our ignorance, we could not even utilize the Constitution, because some people continue to say a soldier's Constitution. But then we can see the powers we have to the point of determining our own income, where the executive rejected it. But we relied on the Constitution. By force, they must do it. And the Accountant General had to do it because of what was read in the Constitution. We could not master our own domain and to be the architects of our own destiny by virtue of ignorance. And that ignorance must not continue to be replicated by not understanding what is before us, Honorable Speaker. The objects are clear, the reasons are clear, that we assign them to do all these things, Honorable Speaker, and if you go, the thread of this Constitution is all the 20 chapters is precisely based on what we assign them to do. So are we now going to transform ourselves into drafters? Then why did we assign them the responsibility? Why didn't we do it ourselves? Because that was said in the first place, Honorable Speaker, that they are asking us to promulgate on the basis of Section 226 of the Constitution. But, Honorable Speaker, Section 226 has two elements. And those two elements cannot be the same. One element are the provisions in the 1997 Constitution that can be amended through and by this Parliament without having to send anything to anybody for a referendum. And that is very clearly stipulated under Section 226, 1 up to 3. So it is important, Honorable Speaker, that we look into that. Honorable Speaker, it says, and it has been read, but I will refer to it to emphasize, for the sake of emphasis, that subject to subsection 4, a bill for an act of the National Assembly, unless this section, under this section, shall not be passed by the National Assembly or presented to the President for assent, unless before the first reading of the bill in the National Assembly, the bill is published in at least 2 issues of the Gazette, the latest publication being not later than 3 months after the first, and the bill is introduced into the National Assembly not earlier than 10 days after the latest publication. So it gives a limit of 3 months, 10 days to ensure that it is introduced before us. When it is introduced before us, it says the bill is supported on the second and third reading by the votes of not less than 3/4 of all the members of the National Assembly. What happens after that? It says under subsection 3, if the President fails to assent within 30 days to a bill passed by the National Assembly in accordance with subsection 2, the bill shall be referred to the Speaker, who shall refer it to the Independent Electoral Commission. The Independent Electoral Commission shall cause a referendum to be held on the bill in accordance with subsection 4, and if the bill is supported on such a referendum by the majority of voters provided for in that subsection, it shall again be presented to the President for his or her action. A bill to any act, well, that is the first element. Honorable Speaker, it means this National Assembly does not have monopoly like we have with other laws, where we pass and the President must assent or return it to us, and when we return, by force he must assent. But when it comes to the Constitution, when he rejects, we must go to a referendum. So there's nothing we can do here, change anything, that we believe whatever we change is something that must go to the President. And if he rejects it, we must go to a referendum. Now, what is the second element? The second element deals with subsection 4 to 7. It says that a bill for an act of the National Assembly altering any provisions referred to in subsection 7 and subsection 7, those are the entrenched clauses. So when you have the entrenched clauses, shall not be passed. We are not supposed to even pass it. Shall not be passed by the National Assembly or presented to the President for assent. So it's not even passed, it's not presented to the President. So what Hapul said, it said that the bill, a bill of that nature, unless the bill is published and introduced in the manner required by paragraph B, paragraph A of subsection 2, which we have passed, the bill is supported on the second and third reading by the votes of not less than 3/4 of all the members of the National Assembly. Supported, not passed, supported. Now, once it is supported, the bill has to be referred to the Speaker, has been referred by the Speaker to the Independent Electoral Commission, and the Commission has within 6 months, bear that in mind, has within 6 months, so you see how we are getting tight, has within 6 months of the reference held a referendum on the bill. So within 6 months, the IEC must hold a referendum on the bill to deal with entrant clauses. Honorable Speaker, it is important to see that the IEC is scheduling a referendum in June 2021, according to its calendar. So you see how things will have to change. And it is this National Assembly that must be the game changer. This is our responsibility. That's why we're an oversight institution. All these people are coming to us with hope that a way must be found to be able to address the context that we find ourselves. So, Honorable Speaker, it is emphasizing then that how will it pass? At least 50% of the persons entitled to vote in the referendum have taken part in the referendum, and the bill is supported in the referendum by at least 75% of those who voted. Now, the critical situation we have here is that the draft constitution has both provisions which touch on the entrant clauses and provisions which we can change in this National Assembly. That's why when we started the debate, it was felt that we're going and changing what we could and going for a referendum to the others maybe would have been the best judgment. But that is history. Now we have taken this route. How do we come at a level where we see light at the end of the tunnel? That is really what we must discuss. That's the essence of what we are doing here. We're looking at the merits of the law to assist us to achieve the objects and reasons that are put before us. Promulgation of the draft constitution and repeal of the 1997 constitution. How are we going to achieve that? So, Honorable Speaker, looking at the situation, you will see that it becomes very significant to look at clause 9 of section 226. It says in this section, reference to this constitution includes reference to any law that amends or repeals, replaces any of the provisions of this constitution. Reference to the alteration of the constitution includes references to the amendments, modification, or reenactment with or without amendment, or modification of the constitution or of any provision of this, for the time being, contained in this constitution, the suspension or repeal or the making of different provision in lieu thereof, and the addition of new provisions of this constitution. Now, if you look at the situation, you will see that it is talking about reenactment. It is talking about modification. It is talking about amendment of different sorts, with or without amendment. So elements are sieved out as to what alteration means. Now, how do we promulgate? Is there anything in Section 226 that shows how we are going to promulgate a constitution with both entrenched and non-entrenched clauses? Well, that is the issue here. So it is important for us to look at this critically and for the mover to look at this critically so that we know exactly where we are going. Honorable Speaker, if you look at the 1997 Constitution, you will see in the transitional provisions Section 232, page 122, is where you find the transitional provision, but it has schedules. And the second schedule, 123, tells us at paragraph 2, election of the first president. Notwithstanding any other provisions of this constitution, the person duly elected president of the Gambia in accordance with the Elections Decree 1996 shall be the president of the Second Republic of the Gambia and shall assume office as president on the date he or she is sworn in. The first president shall hold the office of president in accordance with the provisions of this constitution. This constitution shall come into effect upon the swearing in of the first president. There was no assembly when the president was elected. The president was sworn in, and that was deemed to be wrong. And the Chief Justice acknowledged that when that was criticized, because he saw that the swearing of the president should have brought in the Constitution into force, and how can a Constitution come into force without a National Assembly, without the bodies in the Constitution? So they had to wait up to the National Assembly elections before the president was sworn in again, so that the Constitution will come into force. Then they rushed the Constitution before that to the National Assembly, so that the National Assembly will promulgate it. And this Honorable Willie West refused at that time to engage in that exercise until the president was sworn in, so that the Constitution will come into force. Now, how will the draft Constitution come into force? We will not look at the details, but I am sure they know the details. And if you look at the details, we're saying after a referendum. Now, we are told in 1997 Constitution, a referendum within 6 months. Is the IEC ready for a referendum? It's envisaging 2021 June. So in that regard, could we resort to something else to try to remedy the situation? Look at Section 102. Section 102 of the Constitution, Honorable Speaker, is actually telling us that Section 102E, that any bill introduced in the National Assembly may include a bill, may include in the bill a proposal for a referendum on an issue of national concern defined in the bill. Of course, promulgation of a new constitution is a matter of national concern. The mover should look into this possibility and see whether we could not add 226 with 102 together. Somehow move towards a referendum where it will be introduced in the bill that we move to a referendum. And members, it is clear that if we touch even a scratch in this, and we believe we have power to do so, we must send it to the president. And if he rejects it, we'll go to a referendum. And some of those who are trying to read the mind of the executive, I don't know how we've become psychologists as National Assembly members. What I see before me, Honorable Speaker, is the Honorable Attorney General and Minister of Justice. That's what I see here, who belongs to a cabinet, who had the responsibility. The president who presides over that cabinet has the responsibility under Section 21 of the Act to receive this document. It says the Commission shall, upon the completion of its work, submit a constitution and a report thereon to the president. That has been done. What should happen after that? Publication by the Commission. The Commission shall, upon the submission of the draft constitution and report to the president, publish the constitution and the report. That has been done. And not only that, the constitution and the report may, in addition to being published in the Gazette, be published in such other manner as the Commission considers fit. That has been done. And it is the Honorable Attorney General who laid this motion and this bill before us. So the issue is not about the executive, it's us. The executive did not touch it. Yes, the principles are there. For example, Honorable Speaker, the principle of the secularity of the Gambia. It's not written there directly. But if you look at 88, that was the problem we had in the past, where a president would just get up and say, I've declared Gambia as this state. 88 is restricting that. Yes, maybe it should be entrenched. I've not seen that it is entrenched, but it should be entrenched. But you look at 153, we cannot pass any law that declares a state as a particular state of this form. So that is clear. Now, the contradiction in terms of object and reason, Honorable Speaker, some are saying that is not adequate. Put secular there, and don't put Sharia there, because that will show that you are aligning with a particular religion. Let us look at these principles very clearly. What is best is to have put secular. But within the context of the Commission, they say, well, this is what we can put. That's the job we assign them. That's what they can do. That's the context and the content. That's what they can do. But to those who may say, I will vote against this constitution because secular is not there, well, they must rethink. Those who will say, I will not vote because Sharia is there, they must rethink. Because the fundamental rights and freedom gives power not to be discriminated. It's an equality principle. Whilst a religion may have its peculiarities to those who believe in it. So if the religion says this is how you should share, based on the religion, because the obligations are different, and it is not put in the constitution that the laws of that religion is respected for those people who believe in that religion, it means that you can rely on the state, the constitution, on the discrimination clause to claim for a right that goes against the very principle of that religion. Then why don't you just abandon the religion and go and marry have a state marriage? Or convert to another religion? Why should you worry to belong to a religion that you don't have faith in? Nobody stops you from doing that. And those are the safeguards that we must put into consideration to be able to move forward, to respect the group rights, to explain things very clearly so that we understand that we want a united Gambia and we want to move forward. Yes, there are inadequacies. A citizen is a citizen, for example. Why should you say that somebody who have acquired the citizenship of another country cannot stand here and be a president in the Gambia? Why? Because the whole purpose of expanding your territory is for your people to go and become somebody else as long as they are loyal to the state. You could say, for example, that yes, you can stand for election, but then once you are elected, you must renounce the citizenship of another country. So it's how you frame it. You can say that once elected president, you cannot continue to maintain the citizenship of another country. But you cannot say somebody, I'm just saying, these are general things that we can continue to fight for, eventually for amendments. But should we say no to this because of those things that we know ultimately we'll have to fight for in order to achieve? Well, that is the question before us. That's why we're talking about context, determining content. Even those people who are part of the commission may have certain beliefs, ideologies, thinking, strong ones. And when they look at the provision, they may really want to rebel against themselves. But what can they do? Because maybe doing certain things will make others reject. And therefore, will you succeed? So therefore, context will therefore determine content, and that's what this assembly should bear in mind. That each of us, as the member for Woolly has said, in terms of citizenship, but some will go against that. So if it's put there, what would they do? So essentially, they throw it back to us, and we're coming. Know that some people will come with a private member's bill if the state does not come. And the state must get that responsibility. Reject it, fine. And they will know who had rejected this. And then when you want to leave the country and for your brother, sister, to be a citizen of another country, we'll tell them to reject it. Then we see what type of world we'll have. We are ready for that battle, Honorable Speaker, on the basis of principles. But principles must be guided by context. What is achievable at this time is what we should seek to achieve. And Honorable Speaker, I will conclude on that note that if you look at the members of the commission, I see Honorable Justice Chairman Suleiman Jawlo, they're saying QC. I think that's a high judicial status in their own domain. I'm not trying to be ideological. The Pan-Africanist, etc. Well, that's another domain. Come and reach us in our own domain. But here in this domain, it shows capacity to think and situate your knowledge. And that knowledge is being situated to build a constitution of our republic. That's what they're capable of doing at this moment. You look at Honorable Hawa Kurusi Sabali, who was the Attorney General and Minister of Justice in 1997. Institutional memory of the 1997 Constitution. You have Abidjouf Cole, a journalist of profound, and a woman of profound integrity. Dr. Melvin George, you can see just the doctor is enough. Dentist of profound integrity. Fatoumata Jallow, former Auditor General. You see Gay Sow, consultant, legal consultant everywhere. I've met him in so many domains in West Africa, where he is held in high repute. When we look at all this ECOWAS, etc., is a regular consultant. You're talking about national asset. Janet Ramatulai Salajai, who does not know her? These are people who have performed all functions, judicial functions in this country. Who does not know Lamin Kamara? If you have these cases, just go and have a criminal case. You say, who do you think first? So essentially, we are talking about Salimata E.T. Toure, Yankuba Diba, Yankuba Manjang. You're talking about people who, for one reason or another, had something to contribute. And therefore, we should not look at our national assets and try, by all means, to trivialize their efforts and their actions. You can only interrogate what they have done by going and write and show us where their flaws are and how they have plagiarized anybody. But essentially, constitutions, honorable, in terms of principles, in West Africa and Africa, they are talking about constitutional convergence. So the more we converge our constitutions, the more we move towards African integration. So the Gambian constitution ultimately could be a constitution that others will take. That's what we want. That we have added value to it so that others will come and take it and utilize it. This is not a nationalist agenda. It's agenda of building. We are building a better constitution than some of these countries. Do you have term limit in the United States? That is like the term limit that we are talking about. And what I mean by that, do you have second round of voting? Maybe that was not the right question to ask. I'm talking about the 50% majority. Do you have that in the United States? You don't. It's forced past the post. But we are building up an architecture of real democracy. We are talking about 50% majority before you become a president, even if you lead. So these structures will ultimately be emulated in other parts of the world. So in conclusion, Honorable Speaker, I would request ultimately that the mover reviews what has been said, and if we see in certain areas, then what may end up being the best mechanism, because if you look at it, Honorable Speaker, again, that the Commission's term, yes, under clause 8, the term under clause 9, the term of the Commission was supposed to be 18 months, and then it can add another 6 months, and that's why they carried out their work and provided us with what they could provide. Now, we have seen under clause 22, the Commission shall stand dissolved within 1 calendar month after the date of enactment by the National Assembly of the bill introducing the Constitution. Of course, we know that that is not entirely the procedure that ultimately will have to happen. So in that sense, the Commission exists now for the National Assembly. Could we be creative and get the Commission to be able to sit with our committee, not to look at the details of, but to see what people say. Chair, these are the things, and they give reasons why something could be added or cannot be added in terms of the context, so that we resolve this issue in keeping with what is in line with the duty we have given them. We cannot transform ourselves into a drafting committee. It is important that they continue their work, because if we touch it and it goes to the people and fail, who will hold them accountable? Maybe what you put there is why people rejected it. What they put is what they know the people will accept. Let's put it before the people. And then if we need improvement, amendments will come. And maybe some of you may become president someday, and you can introduce a fourth constitution of the Fourth Republic. So it's left to us to improve our constitutions as we go. Thank you very much.
Thank you very much, Honorable Member for Serakunda. May I now call on Honorable Member for Banjul Central.
Thank you, Honorable Speaker, for giving me the floor. Honorable Speaker, I would like to thank the CRC for their efforts that they have done to reach here today. Many Gambians have been yearning for a new constitution, and we have a draft here for us to debate on it. I can see that there are many provisions that many Gambians are happy with. For example, the term limit, 2 terms. It is good for term limit to be in our constitution, because we Africans have the attitude of overstaying.
presidents like to stay for more than 15 years, 20 years, which doesn't favor our country or our continent at large. So coming up with a provision in the draft one, I'll be very glad to support provisions like that one. And the autonomy of local governments and their financial independence. The draft constitution has spelled it out. It is indicated in the draft constitution, which will help local governments to improve, to do many things on their own, both financially and to making decisions too on their own. Honorable Speaker, it is also gender balance. It is advocating for gender and for the youth as well. So, and there are so many others which I cannot mention at the moment because I cannot take the time of the whole assembly. But there are some provisions that I have objects that I am not in support of those sections, which one of them is constitution, that the constitution cannot be challenged in courts. We are in a democratic world now. This is not democracy. We should recall that we should recall about the case of Kemeseng Jammeh and about the case of Honorable nominated member Yakumba. They had cases and they challenged it to the courts and they won. And this is why Honorable Yakumba is still here. So if you happen to put this into our constitution, okay, no problem.
Point of clarification. Honorable Speaker.
Honorable Member for Serakunda, point of? Honorable Member
It's point of clarification. He's allowing me.
Do you allow him to?
Sure, I allow him.
You can go ahead.
Honorable Speaker, I just didn't want to extend the debate. The supremacy of the Constitution is also under the 1997 Constitution. You look at it, it's the same. It's almost like a carbon copy. Honorable Speaker, what it is saying is clear that the Constitution and laws of the Gambia. So you may look at the draft Constitution, you will see almost the same thing, is that this Constitution is the supreme law of the Gambia, and any other law found to be inconsistent with any provision of this Constitution shall, to the extent of the inconsistency, be void. So it's the supreme law. It is not saying, in fact, what it's telling you is that if laws are made and actions done that are in contravention, you can go to the courts and challenge it. That's what it is saying. So it's not saying you cannot, you can challenge, and it's in fact giving you the basis to do your challenge. And that's why those cases you mentioned happen.
Thank you. Thank you for the clarification.
Thank you, Honorable Member for Banjul Central. You may proceed.
And secondly, the appointment of judges and ministers. There are some appointments that are political. It cannot come to the parliament, I believe, because appointment of ministers should be from the executive, should be from the president. If we can say that if the president should appoint ministers, cabinet ministers, there should be requirements that the ministers should have qualifications and experience. I will agree. But those things should be left to the executive. There should be separation of power. The powers of all the three arms of government should be given to them. If, like for example, the powers of the National Assembly is limited, or the judiciary or the executive, they will not be able to work properly as they should. And even the appointment of judges. So public appointments should not come here. We have an example here. Just few months ago, some of my colleagues, member for Basse, tried to explain, but he was not mentioning the exact problem that happened here. And the member for Java West, sorry, Java Central, but I will mention it. The appointment of Njai Ndao and Mr. Diba, the debate here was political, we all know. So appointments like that should be left with the executive to do that. Coming to the election of the speaker, I believe the speaker should be from the elected members, not from outside. Ghana is practicing the same thing. The speaker of the National Assembly will be from the elected members. If the member for Banjul North happen to win the election, a by-election will happen in his constituency, and another member of parliament will replace him, and then he will be the speaker. So it's fair enough for the speaker to be among the elected members than to be from outside. And I want to talk about citizenship too. We have to be fair enough. We have to give people their rights and their privileges. We have so many Gambians who are outside. And in all our prayers, in all our gatherings, we pray for them to have papers. And we don't want people to have our citizenship here, who have the right and the privilege to have them. We have Gambians, we have a Gambian who was the mayor in the United States, Muriaya Sise, for two terms. In this Scandinavia, we have councillors who are Gambians, and for Muriaya Sise, he was born and brought up and educated in the Gambia. He didn't spend all of his life in the United States. He acquired citizenship there. We have a Gambian who is a parliamentarian in Scandinavia. So we have to be fair enough. We have to reason. And it shouldn't be automatic for somebody whose grandparents are Gambians to have automatic citizenship to be Gambian. We have a population of almost 2 million. If we happen to do that, next 5 years, we will be 10 million. All Senegalese will be Gambians, believe me. So we are talking about so many things, merits, demerits, and the like, but we have to take our time. You know, and people are saying that we spent so much money in this constitution, so we have to approve it. It's not like that. Spending millions doesn't mean that we have to approve it. If you have some things that will not favor us, that will harm us tomorrow, we shouldn't. We shouldn't. And we always call for new Gambia, new Gambia. Yes, we accept that we are in a new Gambia, but doesn't mean that we should compulsory have a new constitution. We should compulsory move to a third republic. So, with these objections that I have here, to be quite honest, if they still happen to be in the constitution, I will not support the constitution. That's my take. Thank you, Honorable Speaker.
Thank you, Honorable Member for Banjul Central. Honorable Member for Latrikunda Sabiji, the floor is yours.
Thank you very much, Honorable Speaker, for giving me the opportunity to take part in this very important debate that we're doing today. And also let me join my colleagues to thank the CRC and then also the Minister of the Executive for the job well done. I said in the section 226 that the first requirement that before the bill is here today has all been met by the executive, and we thank them for the wonderful job. And also, Honorable Speaker, as said by my honorable colleagues, this is a very important document, and we are in a time that we believe that yes, we need to have a new law in this country to guide our operations. But as said by the Banjul North, yes, in as much as we want to have a new law, but also we have the right to look at what is embedded in that law. That is key, that's important. Okay, Banjul Center, sorry. Honorable Speaker, I think my take on this draft will be very, very simple and straightforward. Yes, we know the CRC cannot do all. we assigned them. If you look at the CRC, the act that we passed here in 2017, we assigned them to go and do a job for us. 2017. To go and do a job for us. But in that, if you look at it, we've asked them, if you look at the section, let's say 6, that's the functions of the commission, subsection 2D, come downward, you're talking about the separations of power. We asked them to go and work on it with the separations of power. Honorable Speaker, nobody, no genuine Gambian will tell you that we're not in support of this draft constitution. No, we are not saying that we're not supporting this. But we are saying that we have an observation on this draft constitution that need to be addressed. Simple. Honorable Speaker, we talk about the term limit. Nobody will tell you that they are not in support of the 2-term limit of the president. Nobody is saying that. But what we are denying here, what we are saying here, is that what I am saying is that I am not going to support any retroactive law. Mark my words. This is what I say. I am not saying that I am not supporting the 2-term limit of the president. And this is the key. This is important. We need to know this. Honorable Speaker, if you look at the powers given to the National Assembly, I believe we need a separation of power. National Assembly should be independent. So are the judiciary and the executive to do their job. Now, the appointment of Chief Justice, if you look at the section 190, it's talking about nominated by the President in consultation with JSC, that's the Judicial Service Commission. And I think that the Judicial Service Commission is competent enough to identify the people who are going to occupy those positions. So I am totally against saying the appointment of Chief Justice should come to the National Assembly. I didn't buy that idea. I am not supporting that section of the law. Honorable Speaker, if you go further to the appointment of the ministers, Honorable Speaker, in Acts, much Acts, we want accountability. But let's just reflect our mind on the reality on the ground here. What has happened here? In the appointment of some people, we have seen that some people are politicizing it. And this might continue. So I believe the power given to the National Assembly in the appointment, the President should appoint a minister subject to the confirmation of the National Assembly. I am not in support of that one also. The President can appoint the state ministers without coming into the National Assembly. Because we know ministers are political appointment. But if you tell me that the President can nominate, come to the National Assembly, at the end of the day, we're going to look which party did it belong to. Did he belong to? Did he belong to my party? No, I'm not supporting him. Despite the fact that the person have a quality or he is well educated, but sometimes we are not going to look at that. All what we look at is that, did I share the same political ideology with him or her? This is what is happening. So in that section, Honorable Speaker, I am not going to support that part of this draft constitution. And let me make my stand very, very, very clear on that. Honorable Speaker, if you go to citizenship, yes, accepted by others. But if you look at citizenship, I think we should be very, very mindful here. When you say that you can claim a citizenship of the country through your grandparents in the Gambia, but if you are born in the Gambia here, brought up here for 20, 30, 40, 50 years, yet still you cannot be a citizen of the Gambia. Unless if you just naturalize or you get married to someone who is a Gambian citizen. So what are we trying to say? What signal are we trying to send out to the people? Let us ask ourselves. In Acts, much Acts we want a law. In Acts, much Acts we want a draft constitution, a constitution that is going to guide our operations. You know, we should be mindful. No, that's true. If you look at this one, there is a lot of rights. You have about plus 35 rights. Right to education, right to health, sickness right, old age right, youth right. It's all there. We have no problem with those rights. But the implementation aspect of those rights is what we should be asking. That is the key. The Minister of Justice to tell us what plan did they have for the Gambian people when we pass this. Let's say right of administrative actions, right to trial, freedom of expression, freedom of media, access to information. What plan did they have for the Gambian citizen before we can just talk about right? It's important. Every human being should have a right in a country. That's the key. Honorable Speaker, someone mentions about the selection of a speaker. That's a Banjul Central, if I get him right. I am also in support of that. The speaker should be selected within the National Assembly members, not outside. And the process of also removing the speaker is not clearly stated in the draft. The deputy speaker is clearly stated, but the speaker is not clearly stated. Because if you look at this draft, you say the president can appoint a minister subject to the approval of the National Assembly. But that same president can revoke the appointment of that state minister. That's been confirmed by the National Assembly. So let's balance the two and see. And we're looking at the separations of power. National Assembly wanted to be independent. We don't want any interference of the executive in our job. So why would we interfere in the job of the executive? With this political cloud that we are in today, you can appoint a state minister at the end of the day because of he said, I'm not in the same party with this you, then there will be a lockerhead. The executive will not be able to do their job. So I think that should be left with the executive to decide. That is my take. Honorable Speaker, if you also looked at the Judicial Service Commission, okay, or the judges, the financial aspect of it, I believe what has been stated there needs to be looked at. Yes, we know judiciary, they are independent, and it's a very important, it's a key area. But also, we have to look at the resources available in this country. That is the key. We need to look at that one also. Honorable Speaker, if you looked at section 49 of the draft, and then if you look at the interpretation clause of it, that's the freedom, all those freedoms. Because sometimes, some people have these problems. You talk to some people, they will tell you, yes, in this draft, there's a freedom of expression. In this draft, there's a freedom of education. In this draft, there's a media freedom, access to information. We have no problem with that. Yes, those ones are there. But let's look at the key issues in the draft. We assigned the CRC to go and do a job for us. Yes, they did a good job. Nobody denied the CRC of doing a good job. We are happy with their job. But it is our right. Trust me, not every Gambian, those who are saying this is the will of the Gambian people, not every Gambian, it's not the will of every Gambian people. I conducted a series of a program talking to the Gambian people about the draft. Some people are not happy with it, and others are. So if you tell me that it's the will of the Gambian people, say it is your will. What you want there, that's what is there. That is important. Honorable Speaker, I think we just, let me just make it very, very short. That we just propose those amendments. That's one. Okay, sorry. One, I am not supporting any retroactive law in this draft. That is my first step. I am not supporting the retroactive law. That the terms of I'm supporting the term limit. That's 2 term limit. That's fine. But I cannot support a retroactive law. And also the appointment of the executive, and then also the Chief Justice and the judges of the Superior Courts. That aspect of it, I'm not supporting it also as well. And then let me make myself clear, if there cannot be amendment to those ones, then my vote for this draft is big no. Thank you.
Thank you, Honorable Member. May I now call on Honorable Member for Brikama North. Brikama North, the floor is yours.
Thank you very much, Mr. Speaker. This is yet another historic moment. Any parliamentarian privileged to be part of this will add value to your profile. Something that is happening had never happened 55 years as a nation. To have a constitution built by the people and presented to the representative of the people for promulgation is historic and worth mentioning. Having said so, Mr. Speaker, it could be recalled that in 1960, there was a constitution, even though not independent constitution as such, called the Governor Windi Constitution, that resulted to the first election in 1961. Unlike this constitution, perhaps, it came without that broad-based consultation to give the wishes and aspirations of the people, and the election resulted to controversy. Thereafter, the governor appointment to the executive, P.S. Njai as chief minister, and Sadado and others as members of the executive, some of them had to resign. In that event, from 4th to 11th May 1961, and from 24th to 27th July 1961, there were constitutional conferences to address those issues, and yet another constitution was developed and second election conducted. Then Sir Dauda, his party forming the majority, was appointed as Premier Minister. The Gambia went for a referendum, but fell short to get the total requirement and could not get the self-governance. Sir Dauda was appointed as Premier Minister. Gambia got independence in 1965, but under the rule of the colonial masters, Sir Dauda appointed as Prime Minister in 1965. The country still yearned for a full-fledged independence. And what brought about the full-fledged independence to the nation was the 24th April 1970 referendum, where the country get the total requirement and got the full-fledged independence. Then Sir Dauda became the first president of the First Republic of the Gambia as a result of the Constitution. Then in 1994, there came the military junta, the Constitution was suspended, and the country was ruled by degree for almost 2 years. August 8, 1996, we went to a referendum to vote in for a new constitution. Of course, there were consultations, as earlier on alluded by Honorable Member for Woodley West. But some of us, even though at that time we were not that much politically aware, we were involved. The manner in which that consultation went and the manner in which this consultation went, they are far apart. I will not say there was no consultation, but I could say there is vast difference, the approach and the manner, everything involved. When the Constitutional Review Commission submitted its reports, it was not to the National Assembly that it was presented, but to the military junta. And then the people raised concern regarding whether their wishes and aspirations were captured in the first draft constitution. Observations were made that there were a lot of omissions in the first draft. Instead for the Constitutional Review Commission to go back to the people and redraft what they feel were omitted, it was the military junta that revised that draft constitution. It was that revised constitution, revised by the military junta, that was put to the national referendum. It was said here, the 1997 constitution, even though was voted to the referendum on August 8, 1986, was promulgated when the new National Assembly came in 1997. This constitution, according to a member, suffered a great deal of amendment. To one extent, even entering clause was amended. And then what we saw, a country with a constitution, but the constitution that one would say the executive has overpowered the constitution. 2016, the Gambians saw the need, there is a need for change. And in that change, fundamental in the principle to call for change is to review the 1997 Constitution to provide a constitution that can provide good governance in this country. This was very key. Madam Speaker, December 2017, the National Assembly enacted the Constitutional Review Act. June 2018, the President ascended to the Constitutional Review Act. And then the Constitutional Review Committee is to provide for establishment of the Constitution, to draft the Constitution, and then the process to guide the drafting of the Constitution and the promulgating of the new Constitution for the Gambia. The CRC was established and then sworn in by the President on the 4th June 2018. The CRC first conducted what they call the pre-consultation visits to all the regional administrators and authorities. And then the CRC conducted a wide range of consultation within the country and diaspora. And then they prepared finally their draft constitution that was published on the 15th November 2019. The CRC, having listened to the views of the people once more on the draft constitution that was earlier on presented, did not hesitate, went again on the second final publication of the constitution, and then informed and solicited the feedback on the draft constitution. And then finally, the CRC took the feedback on the proposed draft constitution and prepared and submitted the draft constitution to the President. Madam Speaker, the CRC did not stop there. As Assembly members, we have various documents from the CRC, the report of the CRC, comprehensive report of the CRC of their work, as well as the explanatory memorandum to the draft constitution. Therefore, the CRC has done its work, and the CRC is the body that can effectively guide us as members to get into this constitution. We are not drafters. We are not experts like them. The work that they do is exactly that we're supposed to follow. And we could see from the trend that we're going, they have really done what they should do. And everybody is given the opportunity to put your view regarding what should be in the Constitution. Nobody will be forced to do so, but the opportunities were open. They went to every community. They used all media houses. All avenues were used. So now no Gambian will now say your views are not captured in this Constitution. In the report, the CRC mentioned the draft Constitution comprises some provisions of the 1997 Constitution that the CRC considered appropriate to retain while modifying others. It has introduced some innovations in response to the wishes and aspirations of the Gambian people. The new chapter has been created on national values and principles, leadership and integrity, independent institutions and offices, and land, environment, and natural resources. In particular, the establishment of the National Human Rights Commission and the Anti-Corruption Commission are aimed at ensuring respect for the rule of law and human rights, and integrity and accountability in government. These are engaging phenomena of modern constitutional development. In the report, the CRC concludes, after engaging in a robust and full participatory and inclusive process to canvass public opinion, it is my strong belief, and indeed that of my fellow commissioners of the CRC, that the draft constitution generally embodies the wishes and aspirations of the Gambian people in a fair, balanced manner, and that it will help buttress democratic rule and good governance in the Gambia for generations to come. While the draft constitution, as with any other constitution, cannot incorporate every view and opinion, it is our belief that it is truly reflect the best interests of the Gambia and the Gambians. The CRC commends this report and the draft constitution to His Excellency, the President of the Republic, and to all Gambians to receive and adopt and own. This is the position of the CRC. I think every Gambian that has been following the entire process will be satisfied by the work of the CRC and what they have requested. It's either we own this constitution or we go back to the 1997 constitution. But the CRC is advising the earlier. Having said so, I want to seize this opportunity to commend the CRC for the job well done, and I've noted their requests, and I am in support of the request made by the CRC. Mr. Speaker, the Constitution, the draft Constitution, to say, the 2020 draft Constitution, Honorable Member for Woolly West earlier mentioned, the Gambia as a nation is well defined. In the Constitution, the Republic, as I said earlier on, when the first draft came, there were issues surrounding that area regarding the word circular. I think there is a provision that tries to harmonize that. That is clause 1.3, the Gambia comprises of people of different faith, and every faith shall be respected and treated fairly without any discrimination. In the explanatory note, the CRC tried to explain the misconception that the people may have surrounding the word or exclusion of the word secular. If I may read, restoring Section 1 to this original position in accordance with the decision of the Supreme Court. In 2001, the National Assembly, acting on the recommendation of the then Attorney General and Minister of Justice, passed an amendment to the Constitution, which, among other things, sought to amend Section 1 to declare the Gambia as a secular sovereign republic. That section, being an entrenched clause in the 1997 Constitution, was never advanced to a referendum for approval by the people. Consequently, Kemesi Jammeh initiated legal action before the Supreme Court, which declared the proposed amendment to be unconstitutional. This effectively restores Section 1 to its original image, declaring the Gambia a sovereign republic. Unfortunately, the revised edition of the Law of the Gambia of the 2009, instead of clearly restoring the Section 1 to its original position in accordance with the decision of the Supreme Court, as it should have done, left the word secular in the section and provided asterisk referring to the cause brought by James and Jammeh. Constitutional position, therefore, is that Section 1 of 1997 Constitution remain as it was originally approved at the referendum adopted in 1997 Constitution. With that being, there is no word secular in the current Constitution. So there is no point to say CRC has omitted the word secular in the Constitution. But now when people's views were advanced, concerns were raised, I think the clause that I earlier on read tend to harmonize the situation. Mr. Speaker, if you go to decentralization of government, the point mentioned here, the government and the local government authorities shall cooperate and work with each other to promote the interests of all people, the interests of all Gambians, for development of each administrative area, unity, cohesion, peace between and among all Gambians. This is very fundamental and very key. In a multi-democratic nation, at times we may have a government in power that may not have local authorities, but there is a need for them to cooperate and work together. So having this in the provision, I think, is a new development that can harmonize the coexistence between the central government and then the local government. The national values. This is another important, if not new or close, that is provided. As citizens, we can truly demonstrate to be true citizens if we know what are our values as citizens. And this will be spelled out. And that's what the Constitution is trying to address, so that every Gambian can know that these are our national values and principles. When they are spelled out, they are to be known and then to be carried by every citizen. These are things that are lacking. Sometimes we tend not to have that sense of national spirit, national love. But if we enshrine in our Constitution, we tend to have it, and we tend to know it and own it. On the culture, Mr. Speaker, our culture, is it Madam Speaker? Oh, Madam Speaker, I'm sorry. Madam Speaker, some of us are culturists, and we love anything that can promote our culture. Now, having this been mentioned explicitly for the promotion and protection of our culture in our Constitution is a welcoming development. Our culture needs to be preserved. Our cultural sites needs to be protected. This is in one way or the other that can promote tourism in our country. And we all know very well that tourism is one that can boost our economy. The manner in which the culture has been addressed in the Constitution is in no uncertain term aimed to undermine the promotion of our culture. And to that, this is a welcoming clause in the Constitution. The duties of the citizenship. Mr. Speaker, or Madam Speaker, rather, if you look at citizenship in this Constitution, it has clearly defined what citizenship is. By birth, instead of saying citizenship by birth or by descent. Citizenship by birth. And who is a citizen? If you have been a citizen prior to the commencement of this Constitution, you maintain your citizenship. The other aspect, I think what people fail to understand is, apart from being a citizen by birth, you can be a citizen by registration, and you can also be a citizen by naturalization, but you have to follow the procedures. No matter how long you have been here, if you don't follow the procedures, you have no one to blame. Let's sensitize and enlighten people to follow those procedures so that they acquire our citizenship. But we cannot simply say they've been here for long, therefore they should be granted. What the law says, these are the procedures. If you are not a citizen by birth, these are procedures to be a citizen by registration. These are procedures to be a citizen by naturalization. Simply follow that. There is no ambiguity with that. However, Madam Speaker, under citizenship, the child of not more than 8 years of age, found in the Gambia whose parents are not known, shall be presumed to be a citizen of the Gambia by birth. That one, perhaps, when we get to the committee stage, or when we are to consult CRC once more, we need technical explanation to that. Leadership integrity. Leadership integrity. A nation succeeds with a leader. And the nation fails with a leader. And a leader has to have that degree of integrity and demonstrate that integrity. If the Constitution is trying to highlight that to the better understanding of the citizens, it is our belief that we will put in leaders who have acquired that level of leadership and integrity, because it is in our book. This new clause in the Constitution is very important, as Africa in general, we are getting problems with our leaders as a result of our lack of confidence in terms of leadership and their attitude or integrity after assuming or acquiring power. But if the citizens are aware of this, and since it is in their constitution, they will know what to do. It went further to highlight the responsibilities of leadership. And these responsibilities clearly show what a leader is responsible to do. This is cross-cutting, applying to every office, every institution. Wherever you are a leader. What is expected of you to run that particular office or institution. Financial probity of public officers. It is now well known that if you receive any gift or donation in the name of the state, that should be delivered to the state through the Anti-Corruption Commission. This is also another welcoming development, and if done as stated, will be a way to check corruption in the government and in any public offices as well. Obligation of persons dealing with public offices in the service of the state. People should know their obligations, that you are public servant, you are people's servants, and these are your obligations that you need to carry to serve your people. This is another welcoming provision that will give the people the sense of responsibility to run their offices. In the previous constitution, 1997 constitution, we have the fundamental human rights and freedoms. But the manner in which this constitution has designed this particular area is well commendable. You have part 1 as the general provision for the fundamental human rights, and part 2 for the specific rights and freedom. You have how these fundamental rights are going to be applied, and then how they are going to be implemented. The enforcement of the fundamental rights, and the authority of the court on upholding and enforce this chapter. Limitation of the fundamental human rights, and the limitation of the fundamental human rights. With that, if you know the rights also, we should also know the limits as well. This arrangement of this particular chapter has made the fundamental human rights and freedom to be well understood. And then where we have the loopholes in terms of application and enforcement, the issue of denial of our rights could be addressed. The Independent Boundary and Electoral Commission I share the same view with the Honorable Member for Woolly West. I believe the nomenclature, the Independent Boundary and Electoral Commission, does not actually speak for the purpose, in the sense, independent boundaries. I think the honor lies on the Electoral Commission, not the boundaries. Partly, even in the 1997 Constitution, the Independent Electoral Commission has function to demarcate the constitutions. That's part of its functions. Consequences, rather. That's part of its functions. I believe what should have been done is to maintain the name and then give them that mandate. Instead of creating the Constituency Boundary Commission, we give that mandate to the Independent Electoral Commission, as simple as that. Already, Independent Electoral Commission is an established institution. If you want a change of name, that required a lot of changes and a lot of resources are going to be used in that. And the change of name does not do anything here. All what is necessary is the functions that the commission is going to carry on. Under executive, the draft constitution ably arranged in a way that we have various parts, the guiding principle of the executive authority and general duties. Office and powers, the office of president, powers and duties. What is also important here for inclusion of what is called the temporary succession to the office of the president. And then there was a time the vice president was not appointed for a couple of months because the Constitution did not address that time as when that particular office can be filled or something like that. But I could see in this draft, within 14 days, the vice president should be appointed. I think that will address that ambiguity. The election of the office of the president, qualifications and disqualifications were highlighted, and there were some adjustments compared to the 1997 Constitution. I will wait until when we come to the stage. But so far, it is inclusive. Constitution should not be made in a way to, if we are advocating for franchise, you have the right to vote, but at the same time also the right to be voted for. the law should not be stringent enough to make that exclusion as such. And I could see that in the draft. To take care of the situation and harmonize the situation as well. The terms of the president when we say president, it's not a person, it's the office. That's what we should understand. When we say the Constitution, it's not the president or the person that is the nation. Under that, this Constitution is addressing the office. And the CRC did express that the Constitution is meant for the executive not to perpetuate itself to power. And we all would agree that what has been strongly been advocated as a result of change is this issue of term limit, 2 terms. That is the bottom line of the change. The 1997 Constitution started with what we call President Jawara as the first president of the first of that Constitution of the First Republic. 1997 Constitution came, President Jammeh as the first president of the 1997 Constitution, and if this Constitution should pass, we'll have President Barrow as the first president of the, would it be 2021 Constitution? And the CRC is recommending they start the counting from there. These are experts, taking into consideration how dictators are built. No one is born a dictator. It is the people who make dictators. The more we give them the opportunity, and they tend to abuse. That's how it resulted to. Sometimes they will even go, well, it is 2 terms now. They'll wait until when that 2 terms elapses because already they are dictators. We want you to be there, continue, amend it. The 3 terms comes. Those who are saying we should not start now, tomorrow you are not there. Your target is this, but now the dictator is made. Constitution is amended. The term limit is completely removed. That's why the president of Guinea-Bissau said, inasmuch as we condemn coups in Africa, we should equally condemn them. What is called amending the Constitution to 3 terms. It does not just start there. It started from somewhere. And here we are in that situation. We regularize it now. Or else, I can tell you, whether you'll find me here or not, it is going to happen. Because this is an act of trying to build somebody to acquire that trend of dictatorship. the appointment of ministers. These are best practice elsewhere. The qualifications are there, disqualifications are there. And the executive has the power to do the nominations. The National Assembly scrutinizes. If we are doing for other public offices, we did it here, ombudsman. What is wrong for cabinet minister? The ombudsman, we did it here. And we did it perfectly well. I believe this is a welcoming development. We all know very well there are certain cabinet ministers, if at all they should be put before the National Assembly for scrutiny, they will not be in that office. Anytime they come here, we'll express our disappointment. The way they treat issues, and the way even they address this August Assembly. We say fine, the people's representatives should be given the opportunity to scrutinize who should better work with the president to serve the nation. They say we should leave that. I think this is also a new development. Finally, Madam Speaker, local government, we have the chiefs supposed to be elected as it used to be. But what is lacking is their qualification and disqualification. The Constitution mentioned that, or the draft Constitution rather, the institution and election of appointment of Shefo and Alcalo, the institution of the office of the Shefo and Alcalo as recognized and established by the customs and usage, and the non-abolition of such offices is hereby guaranteed and preserved. A Shefo shall be elected by the universal adult suffrage of all registered voters in the district on a non-partisan basis. That's just that about Shefo. If you talk about their election, I think you should also talk about their qualifications and disqualifications. Because in the First Republic, it was the government that will identify, or people will apply and they will select candidates. Sometimes they will say you come from those from the ruling clan or something like that are the ones who are given the ballot boxes to contest. And then sometimes this is done on political line. But now when the appointment came, whether you are from that ruling clan or not, people are appointed. In the same vein also, even election, it was only the yard owners that used to vote. Now voting has been addressed, but who are qualified or disqualified to contest for the chieftaincy, I think that should be addressed in the Constitution. On that note, Madam Speaker, I thank you so much for giving me the floor. And once more, I thank the CRLC, through the chairperson, the able chairperson, for a job well done. And I urge the August Assembly to adhere to the submission of the Commission, that is to receive, adopt, and on this Constitution as the way forward. Thank you.
Thank you very much. Honorable Member for Nyamina East, Sierra. Nyamina East. Okay.
Thank you very much, Honorable Speaker. First, Honorable Speaker, let me recognize or acknowledge the effort of the CRC, the Constitutional Review Commission, for having done a fantastic assignment, I will call it. Obviously, Honorable Speaker, we are not ignorant of the fact that the CRC was empowered by this August Assembly to go around all over the country and, of course, beyond the country to have that consultation with the Gambian people within the country and outside the country. I can't remember, Honorable Speaker, any individual or this August Assembly asking the CRC to draft this constitution just to suit the interests of an individual, to suit the interests of one political party or one sector of the society. All that they have done is to went round across the country to ensure that the entire Gambian people and all sectors, departments, institutions, and so on were consulted in order for them to better define the way and the manner in which they want to be governed. And that is exactly what the CRC did. The draft constitution that is before us is not just the making of the CRC or the group that was constituted. This was a task given to them by this August Assembly because we believe that not every Tom, Dick, and Harry can be part of that group to have this document drafted. That is why a group of intellectuals, a group of knowledgeable people, a group of well-educated and experienced individuals were constituted so as to have this assignment done. And we were never in any way mistaken when we were constituting that group of individuals that we call the CRC. So obviously, everything that is written or drafted within the seed of this constitution is not from their own imagination, is not just from their own beliefs, is not just from their own write-up, but is from the will of the Gambian people, is from the mind of the Gambian people, is from the aspiration of the Gambian people, and of course, the belief of the Gambian people as to the manner and the way in which they want to be governed. So the CRC, they did what exactly they were asked to do. And here it is. So the question should be, do we really understand or do we really examine the way and the manner in which the CRC were asked to do this assignment, whether it was done in that magnitude or not? If probably things were not done accordingly, then various issues or questions can come up. But I understand from the view of the members that obviously the way in which they were asked to do their assignment, things were done exactly in that way, Honorable Speaker. So, Honorable Speaker, this very assembly, this August Assembly was consulted. I could remember the committee that is established, that is the Standing Committee on Human Rights and Constitutional Matters, and of course the entire National Assembly members were consulted and a position paper was given. Likewise, all other institutions also, they were given certain questions to answer, or the way in which they want to define their institution. And a position paper was given. They went as far as meeting the communities to ensure that they hear from them, to read their mind, to sound their opinion as to the manner they want to be governed. Honorable Speaker, and that was done. But one key thing that we must remember, not every element of the individuals that were consulted must be captured in the draft constitution. That is practically impossible.
that everything that was said by the Gambian people must be captured in this draft constitution. Of course, during the consultation, so many issues came up. Of course, debate was going on when they were making their consultation. We are not ignorant of this fact. People have to debate, others have to agree, others have to disagree. But at the end of the day, what happened is majority carried the vote. And that is exactly how they came to the conclusion on every part or clause of this constitution. So obviously, it will not be a doubt if this draft constitution is tabled before the August Assembly for honorable members to have controversial issues. That is normal. It is very, very normal, Honorable Speaker. But do we actually have to reject the draft constitution because of the controversial issues that we have? Like I said earlier, every one of you and those that are outside listening to you, those who elected us here in this August Assembly, they also have issues that are not just captured in this draft constitution. But like I said, majority carried the votes. So the assignment and the work now that we should do as honorable members, we are just a portion of the general public. And from here, we must understand that this might move to another level and to another level, up to the level of referendum, that we know. So meaning our task here is not just to discuss about this here, but the people outside who elected us must understand every element of this constitution before one will vote either yes or no. Honorable Speaker, that is very important. Honorable Speaker, as most of the members, of course, raise controversial issues or issues of concern, I must also raise some of the concerns that I have, Honorable Speaker. If you get to the draft constitution, Honorable Speaker, I have seen that obviously Section 1953 of the draft, 1953 of the draft, which states that the National Assembly shall not reduce the budget of the judiciary below the amount approved in the preceding year. Obviously, Honorable Speaker, in as much as the National Assembly is concerned, we must not undermine certain things if we believe and if we are given the powers by this constitution that we are the ultimate institution to allocate resources of this country. Obviously, we have the right to touch every sector of the budget. What of, Honorable Speaker, if we are able to touch other institutions, like you talk of other ministries, but not the judiciary? Honorable Speaker, that does not sound well to me. Every sector or every ministry, as long as budget scrutiny is concerned, we must be given the mandate. And here we are, that mandate must be here for us to touch every sector that we deem fit should be touched. Honorable Speaker, that is very important, but we cannot have that segregation within the ministries. Honorable Speaker. Honorable Speaker, another point that I have regarding the draft is the term limit, Honorable Speaker. I know most of the honorable members did emphasize about the issue of the term limit. Yes, Honorable Speaker, which is very important, but we must understand the rationale behind this. We are advocating for two-term limit. Of course, that is what we are advocating. And others who are, of course, saying whether the incumbent, the current president that we have, or the current term of this president that we have, should be inclusive or not. This is a question and it's a debate. But if you understand what we are really advocating, then you will begin to understand or accept the rationale behind this. We are advocating for two-term, whether this term is inclusive or not, but as long as an individual serves for 2 terms, whether this president or the coming president, that should be enough. That is what we are talking about. So it does not matter. And we must understand that
This is not just from an individual. Everything that is written here is not just from the CRC members. The entire Gambian people recommended that this current term of the president should be inclusive. So you and I as an individual, we are saying no to it. Or do we just have to vote against this draft constitution because of that provision? After so much effort, after so much investment, after so much time, the long-awaited draft constitution just have to go out there on the dustbin. That is very unfortunate and a very bad history for that matter in the long run. Then we are all trading on the side of history, on the part of history, and one day history shall judge us. That is obvious. Here we are talking about the 1997 Constitution. Today, most of the people will keep blaming, for instance, the former government for having brought this 1997 Constitution. Others will say that it's because of history we are talking about all these things. Today it is our time, we have the opportunity, we have the chance to start correcting some of the things that we believe that they are wrong. So obviously because of one element, because of two elements or controversial things that you have in the Constitution, that should not just make you to throw out this Constitution. Because your vote matters. Your vote counts a lot, as long as the draft is concerned. Honorable Speaker. So that is the concept, and that is the belief. Whosoever starting from now, this is the view of the Gambian people, is the belief, and this is what they want. So obviously, after going around the entire country and beyond the country, having accepted this and it is drafted, you have nothing to tell us, you have nothing to do but just to say no against this constitution because of that provision. The advocacy is 2 terms. An individual serving 2 terms, then you have to lead the way. This is what we are talking about, Honorable Speaker. The other point, Honorable Speaker, is about the Honorable Speaker, is about the National Assembly. For instance, Honorable Speaker, under section 124. Today, most of the members, I heard them, of course, talking about whether do we really need to have the president appointing the ministers or the cabinet members automatically without subject to the approval or confirmation of the National Assembly or not. Honorable Speaker, I have a different view. In as much as we want to promote independent institutions among or within the 4 arms of government, that is the legislative, of course you have the judiciary, and of course the executive. My view and my take is that, Honorable Speaker, we have to leave everything on the hands of the executive, of course I mean the president, to do this appointment. We should not have any hand as an oversight institution to be part of the appointment of the ministers. That is my take, that is my belief, Honorable Speaker. The National Assembly is given the power if you are not satisfied with any minister appointed. If any minister happens to commit something that is to the detriment of the Gambian people, of course, you have the right to cast a vote of no confidence on that very minister. That chance is there. So the issue of competency that can always be ascertained by this National Assembly as long as oversight function is concerned. This we must note, Honorable Speaker. Honorable Speaker, in conclusion, like I alluded earlier, Honorable Speaker, here we are, and we are not ignorant of the effort of the CRC. We are very much aware what they have done, and the entire process was actually accurate, because I didn't have, of course, any member challenging the process that was undertaken. Honorable Speaker, obviously, like I said, every institution, every department, every sector of this
very great nation. They have issues that are not obviously captured by the CRC. And these are things that can be remedied in the long run. Honorable Speaker, as a result of that, one does not just have to reject the entire constitution because you are not in agreement with what the CRC recommended or what the Gambian people recommended as per the term limit and the inclusion of this current term of the president, Honorable Speaker. Honorable Speaker, one does not just have to reject this present constitution, this draft constitution, because of a right that forms part of the draft constitution that obviously the government does not have the capacity to fulfill. These are things that we can correct in the long run, Honorable Speaker. One does not just have to throw out this draft constitution, Honorable Speaker, because of what? You are not in agreement with the draft constitution simply because you are in support of the 1997 constitution. We all cried, we all struggled, we all battled throughout in the past years to ensure that we have this reform done. And now that it is here, you have no other idea, you have no other suggestion, but to tell the individuals who are out there, your electorate, I mean, because we are seeing what is going on, Honorable Speaker. Having accepted this, at the end of the day, you go out there, start campaigning people to vote against this, it means you are actually jeopardizing the will of the Gambian people. Because considering the fact that 70% or 75% of the people out there are not educated, they are not aware of this, and it is your duty. It is our responsibility to enlighten people, to educate people, to let them know what actually this document entails. You fail to do that, you have nothing to do but to poison the mind of the people, the electorate out there, to vote against this constitution. History will judge you for that. Always remember that, bear that in your mind. So it is our duty. I will urge all honorable members who are here. It is not just one thing to play. Accepting this year or rejecting this year is one thing. But at the end of the day, if we should move to another level, especially the level of referendum, obviously we have another part to play. Considering the threshold, 50% turn out, 75% yes, which is very high. So just one sector of the population going against this constitution obviously might lead to catastrophe, disaster, Honorable Speaker. And that is not what we are praying for. And that is not what we were crying for. That is not what we were aiming for. That is not what we really want to achieve at the end of the day. Honorable Speaker, my position is very clear. And what I am urging other members to do, because of the one element controversial thing that you have in this constitution, should not make you to vote against this constitution. Thank you very much. Voting against the constitution means you are voting in favor of the 1997 constitution, which we were crying for. Thank you.
Thank you. Thank you, honorable members. I observe that there are some honorable members who've been sitting for more than 4.5 hours, and some have been going in and out. So I think it's only fair that we take a short break for lunch and stretch our legs and come back. It's 3 o'clock. 3 o'clock. Do we say we come back at 3:30, 3:45, or 4 o'clock? What's the consensus? Suggest we stretch it 3:45. Yes, 3:45. I think so. So we now, the sittings are now suspended till 3:45. We come back at 3:45. Thank you.
Man kontaan boy mana hen boy nga nyim bata mbe taki tubabu du boy nga nakodo mo be doku boy nga kina nyin kendi moy boy pura e bungolo nyi boro na bungo hani lento am futaje o ite jibe lu njumala ya fanyi ko babun lola ama me ila bungo jibe abadame
jara fo ite lafta fulanye man baluwo kalam
mun baluwo fo baluwo ko budlo ko fanan kele boy
nyim bungo jala be nyamende abe mu baluwo la do ko
nyen kunna soniata ta www.baluwo.com anim baluwo isela bulloran jorangol be sang anila kudola asatare mambata jorangol membu ko sementol kenyo babarol nil peruol woninga nyon jamal ta baluwo.com yen jorangol be sang ila dinkira bado adungite batala je anim baluwo ifangole marate la kudola
man kontaan boy mu ne boy nga ñim bata mu be taki tubabu du boy boy nga nakko do